Directed tomorrow. So I've given the list, maybe called up tomorrow also.
Subject to there needs to be some order from the other. Yes, sir. Yes, sir. Not necessary. Not necessary.
Item retired employee mallet is not getting it pension due to the expenditure.
Yes, today.
Yes, sir. Petitioner is a retired employee mallet is retired as a constable since the last 5 years. Due to pendency, the appeal is not getting his pension mallet.
Of which year?
The appeal of the year 2025.
25.
I have that from the year 1990.
Next.
Well, this is a materiality of appointment of under reality.
Rest of the things give them.
Appointment under reality.
Identical batch of cases has been posted to 10th. 10th, your lordship directed me to give the numbers similar methods.
My lord, this is similar matter already your lordship dismissed the matter. And read
Day after.
Lordship, I have filed an intervention application to be a party in writ appeal, which is pending.
Which year appeal?
24 writ appeal.
24. Proceed to week after next.
My lords, I've given a memo. The date petition is of the year 2012 minutes regarding regulation of helpers working in government printing.
2012.
Yes, minutes. Obliged, my lord.
Pension, my lord. Fresh read appeal of 2024, my lord.
24 week after next.
I may be pardoned to mention, your lordship, from the list of your lordship, item 24, your lordship.
24.
Yes, your lordship, the records are not with me, your lordship, if we can post it for 2 weeks after.
2 weeks at the request.
The last week, my brother-in-law necessary.
Yes.
Your lordship, item 26 also.
26
Records
also.
have not been handed over to us, your lordship, but it's been.
But 2019 matter.
Yes, your lordship, the records are being
At
searched.
the request.
Yes. Obliged, your lordship.
I may pardon, my lord. Item 2, my lord.
Item 2. Wait,
My lord,
what
that
the
batch,
not mentioned, na?
yes, my lord, batch matters, my lord.
Let us see.
I have not, lordship,
Let us see.
lordship.
Yes. Item 1. What is this matter about? Tell in a nutshell.
There is a claim for the enhancement of interest, my lord. They have given 7% interest over 14 and half years delay, my lord.
Of pensionary benefits.
My lord.
You are
And
asking for a higher rate of interest.
that interest I also they have not paid.
Yes, brother, what the learned single judge said?
My lord, may I take your lordship
What
to...
Padmanabhan Nair which is that?
I have cited all the judgments, my lord.
Huh?
I have cited all the judgments,
Cited.
but they have not taken care of any judgment. They have passed the order simply 7%. May I take your lordship para 6.2 of page 54 of the order, my lord.
So then, 6.2.
Lordship got on page 54. Therefore, in view of the decision in the case of Rafiq Masih, this court is of the view that no equity can be...
say anything about interest rate.
Pardon?
Entire Rafiq Masih judgments by Justice
My lord.
are did not
My lord.
one word about the interest.
My lord.
You can go to the next one.
My lord, I have not relied on Rafiq Masih for the interest. Rafiq Masih for the purpose of recovery. They had wanted 21,900 764 as recovery. Therefore, that for the quashing that recovery, that Rafiq Masih judgment has been relied upon.
On interest, you are not.
On interest, I have relied on the written note of argument that I have given here, may be seen, and the circular also of the state government I have given.
Circular says what is the rate of interest?
18.
18.
Government circular. That is annexure 5. That is even relied solely on the judgment of this honorable court. A copy whereof was sent to the government for adhering to it. Annexure 5, page 59. Relevant para 3, my lord. In pursuance of the above orders of the Honorable High Court, Lordship got it page 61, para 3.
So, brother, what do you say?
What is the fresh admission, lordship?
Distribution.
Yes, madam.
Issue notice and we'll call it after 2 weeks.
Lordship.
Only short point.
Like the Because of the recovery part, my lord, the honorable single judge was awarded 7% interest, my lord.
He says, for 14 years you had retained that money. My money cannot remain with you. If you retain, you have to pay interest on that. Interest awarded is at a lower rate. That is his case.
But he was directed to.
No, if you are ready on argument, we will take up the matter on main matter
No,
itself.
my lord, lordship, fresh admission, therefore I am.
Emergent notice, learned ASC. Request with also notice for 1, 2, 3. Accountant General, learned panel 1, 2, 3.
Copy has been given to
Such notice for OP number 4. Give copies.
Look, all persons have been giving us. Accountant General.
You have given the copies. Okay. Since matter lies in a narrow compass, call this the first week of March. Next. Item 2. Yes, 2.
This is a case relating to seniority of assistant section officer in
No,
secretariat.
Mr. Ray wanted some time in this. Number 2, Devra.
Yes, yes, we are ready.
Ready? This is not fresh admission.
In fact, though it is a fresh admission, notice has not been issued, but the other sides have already appeared.
Already appeared.
Already appeared.
Well, there are private parties, number of private parties, whether they have appeared.
No, how they appeared without notice?
They were in cabinet.
They were on cabinet.
देखो भाई check off.
Cabinet, 1 copy of 2025.
All are served.
Yes, cabinet applications were filed. And thereafter, my lord, when the matter was taken up, my lord, the Honorable Chief Justice wanted us to file notes of submission also from all the parties. Those are already.
All right. Then we will take up the matter now.
Taken up.
Okay. All right. All are served.
That we have not.
That we are not sure. That's it. That's right. Otherwise, again.
We cannot pass orders.
In connected matters, notice was not issued.
In fact, there are other matters. In one matter, the caveat has been filed. Therefore, the other matter notice had not been issued. My Lord is right.
The notice has to go now.
If they will appear.
What is the?
But if they have the instruction to appear, then we can proceed.
I'm appearing on all the matters.
Yes.
For all them.
For all the respondents.
Yeah, no, not for all the respondents, Your Lordship, but I think only 3, 4, 7 people were actually the ones who were the writ petitioners.
You came running to the court.
Yes, Your Lordship. So, Your Lordship, actually, I was the lead counsel.
One
there.
matter, there are 25.
Then we will issue. Issue emergent notice. You have to see wherever notice
Is not visible.
Where it is
issue
not
notice to everybody now.
25.
Learned AGA appears for official respondents in all these matters. Learned panel counsel Sri so and so is requested to accept notice for Odisha Public Service Commission.
They have no request. They have no.
No, they have made it. All parties wherever they are there, not that issue emergent notice to all private respondents, returnable within 2 weeks.
who have not been made party. Those who have not appeared.
Appeared through cabinet.
Those who have not.
Issue emergent notice to the private OPs who have not entered cabinet.
Yes.
Who have entered cabinet. First. All these matters in the first week of March 20.
May I be permitted? One aspect. In fact, during the court of hearing, the Honorable Chief Justice has orally directed the State Council, and State Council also intimated that.
No action.
No
action. That was.
My only submission is yes. We actually we are not getting the fruits of the judgment. That is okay. Your Lordship is in session of the matter. Nothing adverse should also happen against the opposite.
Yes.
So it's
Station of the judgment.
The status quo.
the stay should be after hearing us. I think it's an understanding the government will not do unofficially until date the government is going by it. But your lordships, a stay without hearing either side will not be appropriate.
Status quo hasn't been.
No, sir, the status quo. Your lordships, till date status quo has been managed and they are not doing anything. So I think a status quo without hearing both sides. I'm just saying it, let it normally notice go. Because the matter has been heard even by another bench. Until date, nothing the government has done. So I don't think a deliberate order is required. Because we have also not been heard. And I'm sure your lordships, if we are heard, the opposition, they don't have a good prima facie case, your lordships. The three principles of a stay, your lordships, will definitely help us. The government anyways is not doing anything. So let it be simple notice, it will come on March. That is why.
Issue emergent notice first week of September.
This is where the problem is. To be reflected.
That is the problem.
We are on caveat. We are on caveat.
No, what I suggest, whatever arrangement has been made, let that arrangement continue through the.
May I interrupt your lordship? Reasonable within 2 weeks. They post this matter after 2 weeks. Make up and dispose of.
May I interrupt your lordship? In this case, there is a third group available.
Who are you opponent?
No, I am from the respondent, and I represent the promotees who are now sandwiched in between two direct recruits. And as far as the rule is concerned,
how you should be heard? Why you should be heard? You are only responding.
No, I am there. I am before the single judge. I am the petitioner as well.
Question is not that. Are you in appeal?
Yes, no, I am not in appeal.
You are not concerned.
But we are aggrieved because of
we are not giving any interim order.
Yes, please. In that even.
Yes. Reasonable within 2 weeks.
So far the arrangement which was made also.
We are passive. So if arises.
No, we are not, sir, insisting. Whatever arrangement has been made.
My lords, my question is that
the order has not been passed.
Then we write again.
That is exactly. The state council.
We are going to retire.
That's the state council.
In 2 weeks.
Yes,
Give it 2 weeks.
We take up the matter.
Yes,
there is no problem for that. The state council, kindly ask the state council.
Nothing, no. Request for interim prayer at this stage is not considered.
That will
Item 3.
Any other matters are there? Similar matters?
No,
All matters are connected.
Only thing, the office also corporate. How many persons appeared? We have to verify from the record.
That somebody from your office.
Yes, sir. Yes.
Send somebody.
Yes.
So that it becomes easy for
Right.
Verify.
Yes.
Item 3.
Here in this definitely my grievance is very limited. Only an interpretation from your lordship. That is the judgment your lordship may kindly see.
To regularize period of suspension between 1/7/2011 and 24/6/2012.
Subsistence allowance already paid. Only the Honorable Court says regularize the service and pay the arrears. That is my only. In view of this, it is not permissible, my lord.
They said you have to take a decision. That's all. There is no positive direction. How you are agreed by this order?
My lord, your lordship may kindly see page 18.
18.
Yes, my lord. Para 7.1. Therefore, this court, while disposing this application, directs opposite party note 2 to regularize the period of suspension from 1/7/2011 to 24/6/2012 and extend the benefits as due and admissible in favor of the petitioners.
When he was detained?
Detained, my lord.
Detention date is? During what period? Yes, you are for the employee.
Yes.
During what period your client was detained?
That is 1/7/2011 to 24/6/2012.
2011.
Yes.
24.
He was
6/2012.
2012.
Subsistence allowance already paid.
One second. No, why it should be regulated? What is there for the employer?
That is as per the regulation, my lord. That is a separate regulation.
That is at page 16.
Yes, my lord already.
Page 16.
indicated that your lordship will find you have not produced the regulation, but the regulation is like, there is also my lords of, my paragraph 7, my lord have a glance.
Can I kindly give the regulation?
Yes, ma'am.
Okay.
One copy. You don't have another copy?
Because I thought
Forget the rest of that, only relevant.
that 21 only. Here by the regulation.
Reproduced in paragraph 5.
Para 7.
Para 7. Para 5. It is
Para 5.
an employee against
Proceedings admissible has been given, but as regards the
we are reading once.
man.
Either for these or her responsibility or the criminal issues of the employee. Shall be considered as a percentage of the pay. Will not be allowed to practically pay and allowances other than circumstance allowance for such circumstances that does not and allowed to discharge on the such duty of the case. So, sorry. What was the, why you were arrested?
I was arrested because of a vigilance case, that is a separate issue. But now you are sorry, Stephen.
That is the issue.
In vigilance case, what happened?
Vigilance, the case is pending.
It is still pending.
It is still pending.
And suppose if you are convicted,
Now, there is no regulation. There is regulation for pollution, but there is a separate regulation. CCR rule is not applicable. CCR rule is not applicable.
Yes.
And your lordship will find the as per regulation 21. My lords have also quoted and also I have indicated what they have said. The lordship will find from paragraph 7 of the judgment. My lords have already said. My lords have also quoted paragraph 5. My lords have quoted. Paragraph 5, your lordship will find an employee against whom proceedings have been initiated either for his or arrest or debt or on a criminal charge or who is detained under any law providing or preventing detention shall be considered as under suspension for a period during which she or he is detained in custody or is undergoing imprisonment. He or she will not be allowed to draw any pay allowance other than substance allowance for such period until the termination of the proceeding taken against him or until he or she is released from detention.
I will not agree with that.
So my lord, and allowed to resign. So my lord,
that means, sir, an employee against whom vigilance case is still pending, his services should be regularized during that period.
my lord, if he is released, that is the regulation.
We'll interpret it now. We'll say what is meant by released.
That is the order, my lord.
That is wrong. Therefore, he is before us.
No, yes, but for that he has not come. Now he is saying that your lordship will find this regulation is specific.
You
I have
are
also
only saying repeating, only
Yes.
repetition of
So my
mantra.
lord, when the regulation is there and there is and the proceeding has already been dropped because after retirement, this present respondent, he approached this honorable High Court and
Vigilance proceeding has been dropped.
no.
Then which proceeding has been
He have initiated department proceeding against the respondent.
It is not on
That
that.
has been dropped because after retirement, there is no provision for initiating any proceeding or continuance of the proceeding. So, my lord,
You will not understand that.
Good communication skill. Question is, the vigilance case still pending.
yes, ma'am.
Courts have taken the view, when the criminal proceedings are pending, a direction for regularization of suspension period is wrong. You are banking upon that regulation. We'll interpret now that way.
Your lordship will again, I can place the regulation 21.
Oh, it's there. You have placed all
Yes,
this.
yes.
You have placed and it is reproduced. There is nothing. We don't agree with that proposition. What we can do is at the most, your request for regularization will be considered depending upon the outcome of the vigilance case. Suppose if you are found guilty in the vigilance case, still this should be done to you. That tramples all known principles of service jurisprudence.
Because it, yes, but because
So therefore, what I suggest is, instead of foreclosing everything here and denying to you, what we will suggest is, we are just asking you, do you agree with that? In the event he comes out clean from the vigilance?
Yes. Yes,
Is
ma'am.
that
Automatically you will get it.
That's one. We'll say only that much.
Yes, ma'am.
Right. This intra-court appeal is directed against a learned single judge's order dated 17/9/2025, whereby respondent employees WPC number 23367 of 2023 having been favored, the relief has been accorded in the following words. 7.1. 7 and 12. Next one. Learned counsel, kindly be seated. Learned counsel, you are a panel counsel?
No, man.
Advocate.
I am.
Learned counsel appearing for the appellant circuits.
I am in the panel.
Admittedly, the vigilance case is pending against the respondent employee, and therefore, learned single judge is not right in according the relief in his favor during the payments. First of all, learned counsel appearing for the respondent employee repeatedly draws our attention to the rule position and says that once an employee who was detained in connection with a criminal case is released, the period of detention needs to be regularized, notwithstanding payment of subsistence allowance. First of all, he heavily banks upon Regulation 21 of recruitment and conditions of service of employees of the State Pollution Control Board, Odisha, Regulation 2011. First time. He adds that the disciplinary inquiry that was proposed against his client has been dropped. Eventually, he having already retired from service. First time. Eventually, not this. He having already retired from service. Also superannuation. Next. Having heard learned counsel for the parties and having perused the appeal papers, we are inclined to grant a limited indulgence in the matter for the following reason. As under and for the following reason. 1. Ordinarily, in civilized jurisdictions, a public employee on being detained in relation to a criminal case by the jurisdictional authorities, suffers suspension from service if that detention period is beyond a particular period, subject to all just exceptions. First, it is admitted in this case that the respondent employee is implicated in a vigilance case and that he was arrested and detained for during the period between 1/7/2011 and 24/6/2012. First time. After his 12. After his release from confinement, during the suspension period, he has been paid the subsistence allowance as admissible under the extant regulations. Is not disputed. First one. Next point. The vehement submission of learned counsel for the respondent employee that under Regulation 21 of 2011 regulations, once an employee is released from confinement, enlarged from confinement, he is entitled to have the suspension period regularized, needs to be examined. First, the said regulation reads as a see, there are 5 of the order. It is quoted. Okay, 21 is quoted. Reproduce. A perusal of the regulations does not support the contention of the kind in as much as still the criminal case, that is vigilance case, is pending before the jurisdictional court, although the proposed disciplinary inquiry has been dropped on superannuation. First of all, while construing regulations of the kind, one cannot keep the common sense in cold storage. First of all, a regulation, a service regulation cannot be read as an act of parliament. First of all, the text and context of the regulations or rules have to be kept in view, consistent with established norms of service jurisprudence. First of all, jurisprudence. First of all, next point. Countenancing contention of learned counsel for the employee would be like placing premium on illegality. And reasons for this are not far to seek. Firstly, the vigilance case is pending against him and he has to face the same. Seventh, during the pendency, the cloud continues on his head. First, if the vigilance case was decided in his favor, he emerging victorious, different considerations would have figured. First, however, that is not the case. First. Secondly, the employees who suffer a cloud on account of pendency of a criminal case or a disciplinary proceeding cannot claim that during confinement period he should be paid from the public exchequer. First off, he can make a claim for regularization of suspension period and grant of consequential benefits only if he emerges. He comes out from the proceedings scathe-free. SCATHEFREE, scathe-free, and not otherwise. First, in this connection, the rulings in the law reports yellow. Yellow. First. Next one. In sentence. Learned single judge's order runs counter to this well-established canon of service jurisprudence. And thus, it has an infirmity warranting interference of this court. First. Next paragraph. The above being said, learned counsel for the respondent employee is more than justified, and learned counsel appearing for the appellant is more than fair. In that depending upon the outcome of the vigilance case, the petitioner can seek regularization of the suspension period. First, that is how the standard textbook writers on service law, like Justice Rama Joyce in his Services under the State Universe, and Mr. Samaraditya Pal in his law relating to public service would say, first one, next paragraph, in the above circumstances, this appeal succeeds. Seventh, the impugned order of the learned single judge is set at naught. Seventh, petitioner's WP number so and so is dismissed. However, liberty is reserved to the petitioner, the respondent's WP number. However, liberty is reserved to the respondent employee to seek regularization of suspension period if he comes out victorious in the vigilance. Yes. First one, in that connection, all contentions are kept open. No force.
Lord, can it be reported? Because in the first case of the police board,
not
regulations you have to interpret.
reporting needs some more research.
Yes.
We don't have so much.
Because this is the first case as far as the board is concerned.
And the precedential value of a judgment does not depend upon its reportability
Yes.
or non-reportability. You can cite it
Yes,
wherever.
man.
Yeah.
Item 4.
Yes.
Lordship, in fact, last occasion, my learned sister had taken time to produce the records, Lordship, the service of requisition resolution on the petitioner.
24.
Lordship, 24, Lordship, 24C, Lordship, that is.
You were kindly just fresh our memory.
Lordship, in fact, Lordship, the no confidence motion.
When no confidence motion was passed,
Lordship, in fact, Lordship, kindly state a writ petition that is Annexure 1, that is on 27/1/25. The subdivisional officer issues notice, Lordship, on the petitioner for fixing the meeting on 12/2/2025, Lordship. 27/1 is the, sorry, Lordship.
one sentence and keep quiet.
Sorry, Lordship.
That the notice is dated
27/1/2025, Lordship.
27/1/2025.
1/2025.
Notice accompanied what?
Without any resolution requisition, Lordship. That the entire case of the petitioner, Lordship.
No resolution.
No resolution, no requisition, Lordship.
The requisition was made when?
Requisition, Lordship, as per their say, Lordship, they are saying, Lordship.
It was made on 11 January 2025.
How many had signed that?
8 ward members.
Total number of members?
There were 2/3, Your Lordship, of the members had signed it.
So 8 members had proposed.
Yes, Your Lordship.
What is evidentiary material with you, madam? Government madam.
Yes, Your
What is
Lordship.
the evidentiary material to show?
Your Lordship,
I am not complete.
sorry.
You should know the question. What is the minimum evidentiary material to vouch your contention that the statutory notice was accompanied by resolution, that is requisition, when it was served on you?
And resolution, Your Lordship, as per Your Lordship's full bench judgment, Your Lordship.
Correct.
Your Lordship may see the first page. An element of prejudice has to be proved by them that the entire process was against the Sarpanch, Your Lordship.
No, we have not agreed with that view. Question is,
Yes.
Apex Court in Jyoti Basu, which I have quoted, I am the author of the judgment,
Yes.
that particular, I forgot that full bench judgment. The full bench judgment says, the Apex Court says in Jyoti Basu versus Devi Prasad Ghoshal, 1982 Supreme Court, it says, law of election in this country is what the statute says, what the act says.
Yes, yes.
So prejudice, principles of natural justice, all these things are alien to law of elections.
Your Lordship may see the first page.
And they have followed Swami versus Returning Officer Namakkal, 1951 or 52, so they follow. Based upon that, the jurisprudence has been developed. Therefore, what prejudice is caused to him is alien to the discussion. Did you, along with your notice, send a copy of the resolution and the requisition? That is the only question.
You should see the first page of the records that I have sent, that you see noting the officer concerned that the copy of the notice should be accompanied with a requisition and a resolution copy.
No, he has said law.
Yes.
Whether it was done is the question.
Yes. And the Panchayat Executive Officer, C/2, has handed over the same. But there she has said that's the returning of officers' views that I have received the notice and I've received the copy of the notice and the resolution and all from you, but not from the ward members. That is what she has said, and there's a photograph. So the officers here.
Dispute is about the postman.
Yes. And we have
postman brought that.
Yes. And we have also annexed, Your Lordship, in the counter affidavit, the copy of the receipt of the speed post, Your Lordship. Now, Your Lordship, one paper of the notice will not weigh more than 3 to 4 grams, Your Lordship. One single paper, if only the notice was there, that will not weigh more than 3 to 4 grams, Your Lordship. The receipt of that speed post, Your Lordship, shows that it is 20 grams each.
20 grams.
Yes, Your Lordship.
In A.B. Majumdar's law of notices, he says, when the law provides a certificate of posting, is it?
Yes, yes.
In fact, no, that is also not true.
No, Your Lordship.
That is also not true. So I can convince that. Only, no.
Not certificate of posting.
No.
Yes, yes.
No,
there is some rule.
Yes.
Your Lordship is clarified. Your Lordship is clarified in
24(2)(d), Your Lordship.
Lordship, kindly.
The aforesaid notice shall be sent by post under certificate of posting.
The only notice, Lordship, Lordship says C is mandatory, which Lordship carries notice, requisition, resolution. D is another provision, only so far notice is concerned. That is only.
Notice means, the student means uniform and school baggage. Here, law says,
Lordship,
notice should be accompanied by
Lordship,
requisition
and
requisition.
Lordship.
Is it right?
2 mode of notice, Lordship. In 24, Lordship, kindly have Lordship, cost of repetition. Lordship, kindly see the section 24. Second, Lordship. Lordship, 24C says, Lordship, the subdivision officer on receipt of such requisition shall fix the date, hour, and place of such meeting and give notice of the same to all members holding office of the date of such notice, along with a copy of requisition and the proposed resolution at least 15 days before the date so fixed. It is independent, Lordship, so what it is mandatory. Then, Lordship, kindly come to D. D says in the aforesaid notice shall be sent post under certificate of posting, and a copy there shall be published at least 7 days from the date fixed for the meeting in the notice board of the Samiti. The 2 are distinct provisions, Lordship. That's why E is there, Lordship. E says the proceeding of the meeting shall not be invalidated merely on the ground that the notice has not been received by any member. So, Lordship, here legislatures had made 2 different provisions. One's notice along with the requisition resolution granting 15 days time, and separate provision for the notice of the voters of the, let's say, information of the voters of the Gram Panchayat. So notice carries only 7 days time, and it will affix on the Panchayat board, Lordship, for knowledge of the voters of the constituency. If that notice is not served, then it will not invalidate the entire meeting, he says, Lordship. The Lordship clarified Lordship judgment, and that was in full bench judgment. So there are 2 distinct provisions, and legislators knowing fully well the mode of service that has been clarified in 2 modes of provisions, Lordship.
All members, because all they have to participate. The aforesaid notice means this notice on the therefore, there is no other notice. It shall be sent by. What is meant by aforesaid notice?
Aforesaid notice means a notice which is sent along with the requisite resolution. Notice is same lordship. Notice is one. Notice issues lordship annexure 1 by the sub-collector fixing date, time and lordship, date of no conference motion, giving notice to everybody, to all the aggrieved parties, stakeholders lordship.
Right.
And the notice, she says lordship, notice has to be served along with the requisite resolution granting 15 days clear dead time to the aggrieved parties lordship. That is C. So that they have the lordship, they have complied.
C says to all.
To all lordship. That has been lordship clarified that they have complied in annexure 1. Well, lordship, my endorsement is on page 20 of the writ application. Clearly I have stated you have not served me copy of original requisition. By their messenger, I have gave objection on endorsement lordship on their notice itself. That is annexed and that is on the record also.
No, that is your case. But now is that you said that the 7 days time is to be there. 15 days time and the mode of service of notice is under certificate of posting
7 days.
D.
7 days time.
No.
So that lordship D 7 days notice.
For meeting.
But
Prior to the date fixed.
date fixing lordship. That is the notice. So that's why E says lordship. If notice is not served, it will not invalidate the inter proceedings lordship. But your lordship, C is mandatory, granting notice, requisition, resolution, and granting 15 clear days time. That is lordship. Your lordship.
That is there, your lordship. C by 2, your lordship may see the returning panchayat election officer on the, he has written. Panchayat executive officer, sorry. Panchayat executive officer. He has given a noting to the video saying that he has personally served. There's a photograph of him serving the personal notice, your lordship, to get with the requisition and resolution.
The requisition also.
Yes, your lordship. And when he talks to the Sarpanch, he says, he's quoted here, that I asked her that why are you saying that you have not received a copy of the requisition and resolution? She says that I have received it from you, but not from the ward members. That is also, he has written officially, he has written to the video, your lordship.
The date is important, lordship. Can you see he has given this order on 15/2 after completion of more than 20 days, lordship. 15 days, lordship. This notice they have annexed. It is after that. And it is dated for the case purpose only, lordship.
That I did it on 29/1/2025, your lordship. He's written there that with reference to the subject cited above, I am to state that I have received the letter under reference from GPDO Kotpat on the same day, that is on 29/1/2025, and the same is served upon the Sarpanch Guwali GP on the same day, that is on 29/1/2025, along with the letter of requisition and the meeting resolution of the ward members. She received the same from me and put her signature on the receipt copy, writing resolution and requisition copies not received with objection. I received this notice 11/1/2025. I asked her, why have you written that? You have not received the resolution and requisition copy, though you have received it from me along with a letter from Sub-Collector Jaipur. She replied that I have received the letter along with resolution and requisition copy from you, but I have not received.
Which is that document?
That is Annexure C by 2, your lordship, page 12 of the counter affidavit, your lordship.
Annexure?
Annexure C by 2 of a counter affidavit, your lordship. It is also there on the pink flag. Yes.
Page 12.
Page 12. So she says, I have received the letter along with resolution.
Even on 15/2. This letter was
15/2, your lordship, reporting you to the video, but he has said that I have done this and I had given her the copy. There she's endorsing that I have not received a resolution requisition. There he asked that why have you done this? No, I have received it from you, but not from the ward member.
That he has said. Show that.
There she has said that.
That inverted commas.
Yes. I have received the letter along with resolution requisition copy from you, but I have not received the same from the ward members. Photographic evidence is also with me while she is receiving the notice. Along, again, the Jona Sahag ADEO and peon of concerned GP were present during the service of notice along with requisition and resolution. He was accompanied by 2 other officials also, your lordship.
As you kindly come to page 20, lordship. Very peculiar submission, page 20, lordship, you kindly see. Page 20 of the read application, let's. Let's go to page 20. Read petition, let's. 20, let's. Lordship already indicated two dates, Lordship. Date of notice is 27/1 to 25 and date of election, Lordship, 12/2 to 25, Lordship.
Date of notice is
27/1 2025 and date of no contrary motion is, Lordship, 12/2 2025. Date of no confidence motion, Lordship, because the motion already held, Lordship, but due to interim order, it was, Lordship, directed to proceed, not to declare the final result, Lordship. The date of no cover 12/2 2025. Then, Lordship, kindly come to page 20. This is their own official records, Lordship. When I received the notice, this is my objection, Lordship. Kindly see bottom, Lordship. Resolution, requisition copy, not received. With objection, I have received this notice.
Lordship, you have received a notice and you have admitted before the objection.
Lordship, that I will demonstrate, Lordship. Lordship, then kindly come to, Lordship, next, Lordship. Then the date of election, Lordship, 12/2, Lordship. And Lordship, kindly see, and I received this notice, Lordship, on 29/1 2025. 29/1 2025. That is very important, Lordship.
Notice was of 27th.
27.
It on 29.
29/1. Lordship, had it been a case, this report was available to the officer, it could have been reached up to me on the very day, 3 to 4 days before the, Lordship, no confirmation. And Lordship, kindly see this report they have submitted, Annex C/2. Lordship, kindly, this is manufactured, this is created only after getting the interim order before this order by me, only to support their case. This report, Lordship, kindly see page 13. Next page. 15/2/2025. After completion of an entire episode, this officer has created this document only to suit their case. Lordship, kindly see the bottom of the page 13. 15/2. After completion of an entire episode, when they are coming to file a counter before this Hon'Ble Court, they are creating this document.
Was already there.
Lordship?
By then your case was already there.
Already there. I have obtained interim order. They are filing counter by preparing this document, Lordship. Can it be, Lordship, this officer could have been reported on very day to the authority. Next day, they could have been sub another copy to me. After obtaining interim order, when they are preparing counter, they are creating this document. Very funny, Lordship.
Counter is dated what?
Lordship, counter, Lordship, they have prepared.
Lordship, C2 is part of the counter.
Counter, part of their counter, Lordship.
Post litigation.
Post litigation, Lordship. After completion of entire election, no commotion, Lordship. Only to meet our amendments in writ application, they have created this document. It could have been done very day, Lordship, 29/1, it could have been reported to the officer and it could have been served to me.
The records also have it, Your Lordship.
Yes,
The records also have the C/2, Your Lordship.
In record,
Yes, Your Lordship.
you see, there is a tuple section.
Yes.
Is it not? Whether tuple section is here, in that there is such a section in government office where all letters sent, all letters received. There is a section.
Dispatch.
Section in your department.
Receipt in dispatch.
That is receipt and
Yes, it is there.
Is there?
Issue section is there.
Issue section.
Issue section. That we call as tuple section. That issue section will have one register.
Yes.
That notice
Sent.
notice sent along with so and so is sent. Notice, enclosures,
contents of the.
which date it is sent, how it is sent. Any such register is maintained?
Yes.
Maintained. You have maintained register also?
My lord.
To see, because I had called for the records. And
Normally, the letters which were received in the office, there is a register.
Endorsement.
Yes. The letters sent from the office is also a register.
There is a register.
Yes.
But question is whether that the register has a
Enclosures. Enclosures, no, it is not there.
Then we will not know.
Enclosures are not there.
Then secondly, this is 15 February 2025, which is showing.
Yes, Your
The
Lordship.
record which you are now produced. That is of 15 February 2025.
Yes, Your Lordship.
That is post institution of the litigation.
Yes, Your Lordship. But Your Lordship, the photographic evidence is also there.
That does not say whether it is notice, resolution, requisition, all that is not put. There are two ladies exchanging some letter.
Yes, Your Lordship.
That's all. It does not show whether the notice accompanied with the resolution and requisition. Ulben says it should accompany those things. Simple. Now, if we agree with this, then officers may play havoc. They may play havoc depending upon which party the majority will belong.
But Your Lordship, from the records, the flow of whatever the
We
communications
cannot
are there.
infer, we cannot infer. It is 4 grams, but it is now 12 grams, therefore there must be more, we do not know. Such an argument. That's what I am saying. A.B. Majumdar on Law of Notices, famous book, which very old book from Calcutta. He says, if where a mail letter is sent by certificate of posting, presumption is that it is served on the addressee. But there is no presumption that what is the content of that envelope. Therefore, when you are sending this thing, very notice it, instead of putting it in an envelope, you will send the notice itself by certificate of posting, so that he can't say we received an envelope but we did not have other thing, because that itself will be the mail, that itself will be the envelope. That way it should be sent.
Then Your Lordship, there can't be any vision as to what is there in the envelope, Your Lordship.
No, then if at all this letter has been, the report has been submitted by the officer.
Yes, Your Lordship.
The rationale behind this letter would have been considered if it would have been presented immediately after the service of the notice. Mr. Salai is correct.
It's the only lacuna that is there.
Because it is post this case, instruction of the case. The bona fide cannot believe that this is done.
It's the only lacuna that...
Panchayat executive officer. He is not the person who issues the notice.
No, Your Lordship. No.
Notice comes from that particular officer. Sub-divisional
Sub-collector.
No, it is this covered sub-divisional officer.
Sub-divisional officer.
Sub-divisional officer. Whoever is the sub-divisional officer, he has to send the notice. Notice should have a fixed enclosure of resolution and the requisition. There is some meaning why legislature is saying all that. Legislature understands what is the requirement, how it should be done. We cannot sit in appeal over the wisdom of the legislature in election matters. Maybe that he has to let him face another. Do you have the result in envelope?
They have Lordship published, they have unstated minutes in the meantime. Because due to vacation of dismissal of the writ application, in the meantime, Lordship, they published the result as per the provisions, Lordship. Now I am unseated, Lordship.
You will remain unseated only, but let them have one more proceeding.
But Lordship, law says, Lordship, once it is held, it cannot be for 1 year, Lordship.
1 year, yes.
So, Lordship, after 1 year,
It's held. Question of where is it held?
Means it is
no held at all.
No, Lordship, they have both Lordship enter process completed and result counted, Lordship.
Then it will be valid. Held means held according to law.
So it is invalid, Lordship.
Invalid. Therefore, it is not held.
No. So, Lordship, it is open to them to go for Lordship press, Lordship.
Followed on the following terms. One, there is no evidentiary material worth mentioning to vouch the contention of the learned government advocate, AG, that the notice dated 27/1/2025. Kindly give attention to my.
So extreme sorry, Lordship.
27/1/25.
Yes.
Lordship, 27.
Was accompanied by a requisition and the resolution proposing no confidence motion. First off. The full bench in, do you have that?
Yes, Lordship.
So and so has held that the provisions of section 24 of Odisha Gram Panchayat Act 1969 are mandatory. And therefore, in the absence of accompaniment of copy of resolution and a copy of requisition, notice will be hindered. And any proceedings structured on the basis of such a mandatory notice will be vulnerable for challenge. First one. Next one. A.B. Majumdar on notices, law of notice, says that when an envelope is sent duly stamped by certificate of posting and well addressed, there is a strong presumption that the said envelope reached hands of the addressee. And one who contends to the contrary will have the burden to prove. First one. Remember, there is no presumption that a presumption as to what the contents of the envelope were. No presumption can be raised as to the contents merely on the basis of weight of the envelope as recorded by the postal authorities. First one. Therefore, contention of AGA that the envelope was weighed and it was 12 grams.
20 grams.
20 grams. And therefore, presumption should be raised that the notice was accompanied by a copy of resolution or a copy of requisition cannot be exceeded. First, the consequences of raising such a presumption would breed presumption, has a mischief potential. First one. Next one. This aspect of the matter has not been treated by the learned single judge in the right perspective, in our considered. First one. Next one. In the above circumstances, the appeal is favored and impugned order of the learned single judge is set at naught. Sorry. Appellant's WPC number so and so is allowed, and the impugned proceedings at the stage of issuance of notice or quashed. Matter is remitted to the portals of the subdivisional officer for issuing a fresh notice along with a copy of requisition and along with copies of requisition and resolution, fixing the time, date, and place of meeting. Date, hour, and place of meeting. Date, hour, and place of meeting.
It should not disturb in the office in the window.
Afresh.
No.
One more point of the office. The payment contention submission of the debt on still appearing for the appellant, that there cannot be a second no confidence motion, and therefore no fresh proceedings can be now taken up. He is liable to be rejected in as much as the first no confidence motion is being voided. First, when something is voided, ordinarily that will be voided initially. Subject to all just exceptions, into which argued case of the appellant does not fit.
The peace we maintain to this officer.
This appellant will create problem there.
Peace we
That
maintain.
may be protected, otherwise.
This we maintain.
Yes, sir.
Peace should not.
They are
Once
My lord.
you post police there to ensure peace, law and order.
From the notice period.
Because now Naib Sarpanch is in the officiating there.
Snag sir.
After this press, the present appellant, he will speak that I am the Sarpanch.
minor solution. In the meantime, 4 has been disqualified. In the meantime, Lordship, their members, 4 has been disqualified.
Whatever it is.
Please let me complete it. That should be brought to record. What I'm making, we're making police protection. Very funny submission. Man and a message. We keep on seeking.
No, not police. We are not saying that police.
You have unchecked me.
No. Why you are taking that? That way.
You are making that mention.
No. I am
So in them type 4 has
I am
been disqualified.
submitting that.
So it motion cannot be
maintained. He should not disturb there.
That also recorded, Lordship.
It is from the stage of that
Notice.
But Lordship, once they have disqualified, they can participate, Lordship.
Read section 20.
Lordship, I'm reading.
Read section 25.
Lordship.
If you do not read the entire law, this submission will be made. Read 25. Come to 25.3 perhaps. Other day we treated law.
Lordship, without prejudice to the provisions of foregoing section of Sarpanch, Gram Panchayat shall be disqualified to continue and cease to be the Sarpanch.
Kindly read fully.
If he fails to attend 3 consecutive meetings, Lordship, of
not that.
Lordship,
Then after that, there is the effect when they will be seized as members.
Lordship, a candidate who himself through
A candidate who himself or through his proposer with intent to be elected in election.
No, that is not
false information which he knows or has reason to believe to be false or conceals any information in nomination paper and affidavit which is required to be delivered.
that is 26.3 perhaps, Lordship.
26.3.
3, Lordship. 26.3, Lordship. I'm reading, Lordship. Where the collector decides that the Sarpanch, Naib Sarpanch or any members has become disqualified, such decision shall be forthwith published by him in his notice board and with effect from the date of such publication.
The date of that publication.
That has already been done.
That is done.
Done, Lordship.
For the earlier period, they will continue.
Yes.
Lordship, but Lordship, please.
Because they were there under law.
Yes. That may be clarified.
That may be clarified.
That should not, Lordship. Because, Lordship, that is my information that yet to be published, Lordship. That is notified, Lordship, that.
Then they are still members.
Still members, Lordship. Sorry, Lordship.
So we'll record that.
No, that's not required.
Otherwise you will create problem.
Yes.
Yes, your lordship. Now, that is why
We know what politicians will do. In fact, there is a famous book.
They are ruling side lordship.
There is a
But
famous,
we are at
there
recipient
is a
lordship.
famous, you should be.
But
Because
lordship,
you have lost the confidence.
no.
There is a famous book.
But lordship, kindly, one thing, lordship.
If you want to say something,
Right, kindly have patience and listen.
Lordship,
there is a book which says
lordship.
India grows only during night because politicians sleep. That is such a famous book. India grows during night because politicians sleep. If they are not sleeping, we have problems. That way that book is written.
But lordship, for academic proper lordship, kindly say 24-2 for lordship. It will help for all lordship.
24-2.
2 lordship. Because this is the fault of them lordship. The state is lordship sleeping all over the statutes lordship. Lordship, kindly see. That is one of the grounds in our writ application lordship. 24-2.
No, we are allowing everything now.
No, I'm not on that lordship. Just lordship to assist lordship to the democracy lordship only. Because lordship, they are killing democracy. 24-2 lordship, kindly see. These officers, these political leaders lordship, they are killing, every day killing democracy. Because the government changes, Sarpanch lordship, all the Sarpanch lordship, by the use of these ward members, they have never given vote to us. But they are going to unseat us lordship. 24-2 lordship, kindly see. Two lordship, in lordship, married lordship. In lordship, in convening. Only that. In convening a meeting under subsection 1 and in the conduct of business, at such meeting, the procedure shall be in accordance with such rules as may be prescribed, subject to, however, to the following provisions. So, lordship, this is the additional duty of the sub-regional officer. But apart from this, lordship, there must be rules, lordship, because when the statute speaks a particular procedure, rules must be there. And since 1964 to till today, there is no rules. That's all the difficulties are coming, lordship. And every order in lordship is clarifying, in every action of these sub-regional officers is challenging before this Hon'Ble Court, and your lordship is clarifying. Had it been a rules, lordship?
Gram Panchayat rules 2014 do not say anything about it.
Nothing, not a single word, lordship.
But where is the requirement of law? Subject to? Subject to is interpreted by the apex court in which is that
this is the situation, lordship. If had it been rules,
without reading, you are making submission like political speech. You are sorry.
Lordship, no.
Subject to rules means what is already discussed by the apex court.
Lordship.
It says, I think it is a. In fact, a whole chapter is dedicated by J.P. Singh on statutory interpretation. So there are two things. Where rules are a must, you cannot do anything without rules. Number one. Your argument is that.
Yes, lordship.
Other thing is, where rules are not a must, but power lies with the state government to promulgate the rules.
Lordship.
That language is that.
Lordship, something different. May I read at the cost of reproach once again, lordship?
Have you taken up that contention in the repetition?
Yes, lordship. In convening meeting under subsection 1 and in the conduct of business, at such meeting the procedure shall be in accordance with such rules as may be prescribed. Lordship, they have not.
As shall be prescribed, no.
Lordship.
As may be prescribed.
They have not. My contention, lordship. They have not.
May is there.
Lordship.
Because the word used is may.
What is the difficulty I'm coming to, lordship?
Oh, we don't.
Next sentence I'm reading, lordship. Next sentence is, lordship, subject to, however, the following provisions.
Correct.
These provisional additional, lordship. Rules is mandatory.
No, not mandatory. Otherwise, they would have said, as shall be published by the state government. As may be published, may or may not be. That's how courts have interpreted. One whole chapter is dedicated.
It is high time to give a direction to
no
the
direction
rules,
can be given to make rules. 92 Supreme Court read.
But now,
you cannot give any direction to make law. It is for them to make law.
Supreme Court has come up with many cases of direct state.
They are thinking on.
To come up with the rules, lordship, now is judgment also has come up.
Let us. The members as they were when the requisition was made shall participate in the no confidence motion, notwithstanding their membership being forfeited or removed under section 25 of the Act, in as much as the forfeiture or removal shall take effect on such an order being published in the office of the subdivisional officer.
Collector, Lordship.
Collector. The office of the collector.
Then 26.
In terms of section 26. Yeah, 25 is grounds for removal.
21 the Lordship disqualification ground. 26 is the Lordship the provision having effect to Lordship. Lordship only a pray Lordship.
Fact matrix. Such a course is being adopted.
Lordship may only pray Lordship. In the meantime, I should be restored my position, Lordship. Then Lordship, what is remain to be Lordship? They will only Lordship. They are Lordship illegal things only that has been rectified. They have chance to rectify Lordship. Lordship, why I travel this court Lordship without any relief?
Let us see.
Only there are wrong things has been rectified Lordship.
Yeah.
Grateful Lordship.
Grateful Lordship.
Item 5. Yes, next.
May I please?
Yes.
Well, the order for Annexure 13 is being challenged by the petitioner, passed by the GRF, Grievance Redressal Forum.
What is GR?
Grievance Redressal Forum of the Electricity Authority.
Under the OD.
Is it a statutory body?
Yes.
Statutory body.
Statute, under the statute, power has been vested under GRF. License has to establish a GRF, Grievance Redressal Forum.
This is
Under
just
section
like
25 of the Electricity Act.
this is just like consumer forum. Consumer.
Like ombudsman. More like ombudsman.
Milord, if the consumer,
Ombudsman above this.
yes, if consumer will be agreed by the order of the GRF, then he has a remedy to approach the ombudsman. Milord, what I submit, Milord, now he has served me one copy. Let him serve extra copy. The matter may call tomorrow or day after tomorrow.
Give you one more copy.
I'll serve because I didn't know that my learned senior is appearing. For that reason, I could not serve copies. For my practical, may I submit my sorry to interrupt. They have served a notice to disconnect my power supply to my residential house.
How much is the amount due?
Amount now they have served the notice 2,30,000.
Matter was earlier before this Hon'Ble Court. This Hon'Ble Court directed that to approach the GRF. Milord, the bill which he disputes at that relevant point that has been revised. And the revised bill has been served. Now he has not paid any amount. By order of the court, Milord, he has paid 70,000. In 2003, he has not paid any amount, Milord. And the arrear has been accumulated to rupees 2,13,000.
May I pray my learned senior submitted anything. But that is to be adjudicated by your lordships in the present writ petition. The writ petition, earlier writ petition was disposed of in 2024, directing me to deposit 40,000 without prejudice to my claims. I deposited that amount. If your lordship,
what are you doing? What's your client?
Human right defender.
Huh?
Human right defender. Human right. Yes.
You pay that.
But you are supposed to be before the ombudsman, no? Against the order of GRF?
Yeah, he has to go there.
I have come here because the GRF said that the GRF lacks jurisdiction to adjudicate this issue.
That also you can take up in appeal.
But despite that, when the GRF observed that it lacks jurisdiction to adjudicate the issue, despite that, it issued certain directions. For that reason,
GRF has jurisdiction or not?
Yes, Milord.
They should decide this on merit.
Milord, when in the earlier case he has approached this Hon'Ble Court, there was a billing dispute. But in the Milord, long ago, there was an amount imposed towards penalty, Milord.
We are asking. The dispute that was before the GRF,
Milord,
was it within its jurisdiction or not? It was.
Milord, what I submit, Milord, under the new provision, Milord, 2003 Act, Milord, 126 and 127 provisions are there, Milord. But it was a penalty imposed under the 1980 Code, Milord. By that time, Milord, he has an alternative remedy to approach the CEO, Chief Executive Officer of the Electricity Department. That he did not approve. Against the order of GRF, Milord, he has further remedy to approach the OERC. He did not follow that. Now he has disputing that amount, Milord, he has...
What we say is, now there is GRF under the 2003 Act.
Yes, Milord.
So let the GRF take a decision.
They have taken a decision.
No, it said I don't have jurisdiction.
That is not.
They cannot say that way.
Though they directed that it lacks jurisdiction, but he issued certain directions. That is,
but he has not disputed by that time. Can he dispute now, Milord? Because the
No, that is on
fine was imposed on that time.
That is on.
He did not dispute that, Milord.
that I have disputed. That documents are very much available in the record.
Why can't you hear us also? What we suggest, there is a refusal to exercise jurisdiction. Your contention that it arose under the old regime, wherein the grievance officer was somebody else. Now, under the new act, the GRM cannot be accepted. Similar matter is treated by
What I
Kerala High
submit,
Court.
Milord, under the provisions of 98 code, Milord, he has to approach the authority afresh. Your Lordship may. Let him, liberty may be given to approach that authority. But suppose the penalty amount is 1 lakh. Then the rest amount is undisputed, Milord.
That undisputed amount, yes.
Let him pay that amount.
To that effect, my humble submission is that since 2002, they didn't serve any bill upon me. And your Lordship knows under section 56 of the Electricity Act, if the amount is not recovered within certain period, then they have to recover it by adopting alternative remedy.
You whether you want to pay or not.
Yes, I am ready to pay. But what is the undisputed amount?
What is that undisputed amount? They will say that
Yes.
you make payment.
Yes, madam.
And that
Let them
subject
disclose
to-
that.
That now we'll ask them to disclose. Ask
Yes.
telephonic, ask mobile, call your office. What
Milord,
is the amount?
I will
Just
find it
have-
from record, Milord. I will find it from record. A certain quantity was the penalty bill by that time. That amount I can detect.
Ask by phone, by mobile phone. Again for one more adjournment.
Yes, Milord. Another court, 2 cases in court number 1, Milord.
Because I fairly submit my
After
lord.
recess,
I
Milord.
fairly submit my lord.
After recess.
I fairly submit. My lord, after recess, I have some personal difficulty, madam, because some medical emergency is there. So after
For
recess, yes. Because I suffered from an accident day after tomorrow.
Milord.
Because till then,
Copy, one more copy.
till then I may protect because tomorrow is the last
We'll
day.
pay rupees 1 lakh rupees now. We'll protect.
Without prejudice to my claim, my lord.
Nothing. Without prejudice to your claim.
Yes,
Yes,
that can be done.
Issue notice, learned panel counsel Sri so and so present before us on our request accept notice for OPs. Correct?
OP number 1 to 4.
All OPs.
There are 5 opposite.
Grievance forum,
One to
statutory
four.
forum not required.
OP 1 to 4. Notice to 5 is dispensed with.
Yes, Milord.
Dispensed with. Next one. Learned counsel for the your petitioner.
Yes.
Petitioner submits that in the absence of raising a bill for the period in question in respect of power consumption, no liability, enforceable liability arises, and therefore it cannot be insisted that the petitioner should pay any amount during the pendency of this petition. First. On the contrary, learned panel counsel appearing for the opposing OPs, answering OPs, submits that unless the charges are clear for consumption of power, a consumer is not entitled to tap the power at all. First, matter requires a deeper examination. First, in the meanwhile, the OPs are directed to continue power supply, subject to petitioner depositing with them a sum of rupees 1 lakh.
As against the area.
Without prejudice to his contentions in the petition. This amount to be deposited within 2 weeks, failing which OPs may disconnect the power supply. Yeah.
May I fix
All
it?
after 2 weeks.
Yes, much of this.
Item 6.
Look, the last date is tomorrow, so may I prefer supply the certified copy or?
Today you will get.
Yes.
Today you actually take immediately and send our papers.
Mine.
You will get it within 1 hour.
Mine.
But make that. Item 6.
Lordships.
Yeah.
Item number 6. This
Brother, you pay 50,000 within 1 week and the remaining 50,000. You pay 50,000 within 1 week, another 50,000 within 2 weeks. Make it that way. 50,000 within 1 week and another like sum within a week next following.
Nice.
Yes, sir.
Yes. Your Lordship, item number 6, this matter has been wrongly listed before this bench as it was supposed to be listed before the Hon'Ble single bench.
Single judge.
Yes, Your Lordship.
Counsel for the petitioner submits. Matter falls within the roster of learned single judge of this court and wrongly it has come at our registry to verify and do the need.
Obliged.
Item 7. Pass over. Item 8. Yes, brother.
The petitioner is the guarantor as well as the mortgager.
Mortgager.
The petitioner's property in question has been auctioned by the authorized officer without following the due process of law and has not been issued the 8-6 notice, which is a mandatory required under the statute.
Whether you have alternate remedy?
No, alternative remedy is there.
You have an alternate remedy.
This by what are the contentions available here?
All contentions.
Yes.
You appear for the bank.
The Roma is also appearing at times from the side of bank and payment.
He keeps on changing the sign.
Milord, occasionally.
Keeping into the high
Milord,
spec
here, Milord, property.
We don't know.
Milord, 2 crore 70 lakhs. They were sold out to 1 crore 76 lakhs.
We do not know. If we were paid the money, that would not have happened.
Milord. All the contentions. Under section 7.
Petitioner being the guarantor by way of mortgage for the loan in question is knocking at the doors of the court for assailing the coercive recovery proceedings sought to be accomplished under the provisions of Surface Act 2002. First. Learned counsel for the petitioner vehemently argues that without complying with the preconditions, such proceedings cannot be undertaken and therefore interference of this court is called for. Next, Rajiv. Learned panel counsel Sri so and so on our request appearing for the respondent opponent 1 and 2 of OP numbers 1 and 2 submits that petitioner has got an alternate and equally efficacious remedy under the provisions of section 17 of the Act, and therefore this court should not interfere. First one. He also tells us that all the contentions taken up in this petition can also be taken up in the proceedings under section 17 before the DRT. First, we agree with this. Next paragraph. In the above circumstances, petition is disposed of, preserving liberty to the petitioner to avail the remedy as provided under the Act. First, in that connection, all contentions are kept open.
My respect with permission. Dispose of within the filed within 6 months. 4 months statute says. 4 months. 4 months. Statute says.
Should be decided.
within 1 month.
We request the DRT,
presiding officer,
the PO of the DRT to hear and dispose of the challenge, preferably within 6 months. Keeping in view other pressing work. Yes.
Item 9.
There is a limitation also. So period spent here can be discounted. How many? When did you find the petition?
Our knowledge came below. Only
After period spent in prosecuting the writ petition is liable to be discounted under Section 14 of the Limitation Act 1963. While computing the period of limitation, preferring the challenge under Section 70.
Because 1st September 2025, the sale certificate was issued. I took that certified copy from the sub-register office that the government benchmark valuation is 2 crore 70 lakh. No, but they have indicated one here 45 days is all that the limitation.
You can shed your tears in the premises of the DRT.
Yes, including limitation because
no, we can't say the limitation. We can't say the limitation. That way. Only period spent in
yes,
proceedings will be discounted. Yes.
Item 9.
May I please?
Contribution beyond particular limit. We can't do that. Yes.
Item 9.
May I please? Limited prayer of the petitioner, my lord, 4 installments has been defaulted by the petitioner. That is in letter number 22/1/2026.
What is the loan amount?
Loan amount, my lord, 79 lakhs 80,000. Near about
When it
8 2023.
Now what is the rate of interest?
Rate of interest, my lord, as per Annexure 3, page 10.30. 10.30.
10.30.
Now,
is it a simple or compound?
Simple. Floating.
Simple. Floating. How much it will be now?
As on today, as per their notice, 79,000.
No, it cannot be sent.
No, the loan availed by the borrower is payable with interest at the rate of 10.30 per annum with monthly and yearly interest. Borrower have also agreed to pay
additional interest of 18 to 24%
in case borrower commits irregularity.
Default in case of default. Yeah, you have agreed to give that.
Agreed to give the, as per notice dated by 22/1/2026, 3,76,000 as on total. I am ready to pay.
How much?
3,76,000 within a period of about 2 months, Miller. That is my grievance. Annexure 4, Miller.
My lord, we have like the opposite party.
Yeah.
A copy be shot on me.
Give copy.
A copy so that I will take instruction. And then next week it will be disposed of.
4 installments as per my.
What is the exact?
No, what is due now?
Due now, Miller, as page 29.
7 lakhs.
No, they have recalled the loan itself now because you did not pay the installments.
NPA might have been declared.
NPA.
Is it declared as NPA, certified as NPA? No, 32 is issued.
No such.
No, 32 notice as well.
13. This is
32 demand notice only. It cannot be challenged. 32 is not to be challenged because it's a demand notice only.
No, he is afraid now. He says that I will make payment also.
Yes.
How much you will pay now?
All the defaulted EMI, 3,73,981.
No. If you pay 30%, then we will interfere. Otherwise, you are dismissing the petition itself. Because already it has traveled to 13.2.
Instruction. Let it come 1 week after. Brother.
Issue notice. That panel counsel so and so requested to accept notice on behalf of the lender. First one, call next week.
Public.
Good. Come back.
Item 11. 11 मोटा काय तुम लिस्ट काय
If I am looking for the responding, this states opinion, your lordships. Here is, let them start. It's a case of regulation, my lord. It's a case of regulation of the service of the applicant who was working as a pharmacist.
Who is the appellant? Yes, Mr. G.
challenging the order passed by your nurses for a single bench. Page 21 of the current appeal. I am placing them.
Page 20.
Page 20. Order dated 16/9/2021. It is agreed by the Learned Council for the parties that the issue involved in this case is analogous to one
In
involved.
WPC 19951.
Yes. Lordship, may kindly turn to the next page, 19951. Throughout the judgment I had gone through, my lord, they are concentrating on the contractual appointment.
How long they were? So their entry date is what?
The entry date is
31/5/2014, your lordship.
2014. 2014.
Yes, your lord. 14. Against a sanction post having requisite qualification
I'm not
appointed by the competent authority, your lord.
Lordship is right. Simultaneously, I want to draw your lordship's kind notice to the contractual rules.
Contractual rules has been abolished. It's a resolution.
It was by then it was in force. My contention is there was all the posts.
No, whether there were vacancies, the posts and vacancies were available?
My lord, the rule is, my lord, contractual rules 2013.
No, we'll come to that. Mr. G, whether any advertisement given?
No.
No advertisement.
No advertisement. Basing on the representation. But at annexure 2 to the writ petition, it is the appointment of the petitioner. Your lordship may kindly see. For a moment, your lordship, I'll take your lordship to the writ petition.
No, I'll come to you.
Oh, yes, your lordship. I'm grateful.
Who appointed them, Mr. G? Competent authority?
It is the municipality.
Whether is the appointing authority?
Yes, they are the appointing authority.
So posts are there, vacancies are there.
My lord,
Competent authority has appointed.
yes. Simultaneously.
And they have qualification also.
Yes, yes. Here, my lord, the rule says, my lord. It is the rule which says, I am placing status of the vacant posts. For the purpose of contract appointments made under sub-rule 2 of Rule 5, all vacancies existing on the date of commencement of these rules, as well as the future vacancies, shall be deemed to have been converted to contractual posts from the date of commencement of these rules. Rule 6 says, lordship,
They are converted into
contractual vacancies.
these rules were how these rules are made?
My lord, these rules,
No, they are not rules under proviso to 307,
309, 309 rule.
They are not. These rules are made by whom? 309 only.
Made by the government, my lord.
Made under the 309 rules only. The gadget itself shows that, na?
Yes.
First paragraph.
My lord. 309.
309.
It is a 309 rule.
Groups C and D.
Yes. হ্যাঁ 13টা নম্বর 14টা আছে। It's a 309 rule, man.
No, you are referring to rule 6.
Rule 6. By other neither. Oh. It would have quote like eligible. Oh. My lord, the resolution dated 17th September 2013. It speaks, my lord, regular appointment of existing contractual Group C and Group D employees who are not holding any post in contravention to any statutory recruitment rules made under proviso to Article 309 of the Constitution of India or any executive instruction in absence of such rules. It is stated, my lord, that the contractual appointments, engagements made against any contractual vacancy posts created with concurrence of Finance Department on abolition of the corresponding regular posts or contractual engagements, public appointment made against contractual posts created with concurrence of the Finance Department without abolition of any corresponding regular post in case of new offices or for strengthening the existing offices, services following recruitment procedure prescribed for the corresponding regular posts and the principle of reservation of posts and services for different categories of persons decided by the state government from time to time.
What it says, we do not understood.
My lord.
1 kilometer long.
My lord, it
We
means,
cannot walk that distance.
my lord, it means, my lord, in case of regular appointment oblique engagements, my lord, the regular posts have to be abolished. It is to be to fill up the post. It is to be placed before the Finance Department. Finance Department will abolish that regular post, convert it to a contractual post, and thereafter the appointment can be made. It is not that
This resolution is passed under which rule?
309 rule, my lord.
It's also 309.
Yes.
The one which you have furnished to us now.
No, it is there. Hey, madam, please kindly hand over. This is the resolution. Thereafter, the rule can. Wait, এটা তো রুলটা। It's a resolution.
This is the 12th November 2013.
Yes.
Subsequently, rules have come.
Rules have come, my lord.
So this we need not look into.
My lord, since the rule speaks, my lord, that sub-rule 2 of rule 5, sub-rule 2 of rule 5, it also speaks that, my lord. Notwithstanding contained in the relevant recruitment rules or executive instructions as the case may be in force, all appointments made pursuant to sub-rule 1 shall from the date of commencement on the contract basis. It means all the posts shall have to regular vacancies. It is to be abolished. It will be converted to contract. Then after contractual appointment will be made. It is not that the contractual appointments are spontaneous. It is made.
But Learned Judge refers to another decision.
Yes.
What was that decision?
That decision, my lord, it is. They have given so many jobs. That is Vishwamitra Parida.
Correct.
They have given, cited the judgment. It speaks, they have also quoted here.
I quoted and you did not dispute. The facts of this case are similar to those of that case.
Yes, that is what we didn't dispute there.
Then how you
Now,
can be
my lord,
selective in choosing your victims? Is it your case that the judgment which learned single judge has relied upon is not applicable to this case? Have you taken up that ground?
No. This ground, yes, it is not that. This ground has not been raised before the learned single judge then. It is not spontaneous. This ground has not been taken.
Did you take up this ground which now you are telling her in the appeal memo? You have not.
Probably not.
You have not.
They have not.
We can go. I can tell that you are not because by quality of pleadings we can say that.
It is not that.
Then nothing can. You can't be selective. For few, you will file appeal. For few others, you will not. That is the state you cannot. Only Mohammed bin Taghlaq can do that. Not a welfare state. Unless you bring your case into 2016 Supreme Court.
Yes.
Where a very frugal point is involved, it's not, battle is not worth the candle, then all these things will happen. That is not that way. Your pleadings are not structured that way.
No, it is not that. It is not. This question has not been raised in the grounds also in the.
No, have you taken up that?
No, no.
Then we cannot.
It is not that.
Nothing.
I am for the opinion of 3 matter.
Yeah. What you want to say? Something in his favor, so that we will.
I'm the municipality.
He is the appointing
You are the
authority.
appointing.
You have appointed. Why did you appoint?
But that is on
Why did you appoint?
31/5/2004.
Why you appointed? When rules were like this?
Pursuant to government circular. Government, that is a government circular for a pharmacist, appointed pharmacist now. Is a government dispensary, municipal dispensary. Thereafter, the municipal government resolution, they have been observed in the post ballot, the post ballot. And the only contention the appellant in the appeal, writ appeal ballot has taken. I am drawing attention. Dead chart ballot 16/9/2021. That is a dead chart last para. That is dead chart last para. Without any opportunity, the single judge has disposed of the petition. Only this.
No, you are not in appeal.
No, I am not. I am only. I am.
You are selling with them now. You are a respondent. If you were agreed, you should have filed an appeal. In their appeal,
no, I am not
have the bathwater of somebody's.
I am here.
Other person.
I am here. Perform opposite party open 3 matter.
But you are not challenged.
No, I am not done.
So you are selling with them. Even you are standing also with them.
But I am the employer. I am the employer.
You are the employee.
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 Sorry.
Understood.
Yes.
867 days delay.
Yes.
Take. This appeal by the state.
It's a question of law I can raise, my lord.
No, that also you can raise, provided it fits into 2018 Supreme Court, 16 Supreme Court, not otherwise. Where Apex Court said, where the stake involved is very small and therefore you much do not contest and you suffer an order. That ground you should take. In those matters we did not challenge because matter was very small. It was like this. They have given 3 points there. 2016 Supreme Court. If that is taken and reiterated in 2018, if that way your appeal memo is structured, then you have a voice. Otherwise not. I treat your point also. Yeah. This appeal by the state and its functionaries seeks to call in question a learning from the judge's order dated 9/9/2021.
16/9/2021. 16/9/2021. That was disposed of in light of that judgment. It was agreed. Yes. The order is 16/9/2021.
Page 21.
Yes.
Whereby the following relief has been accorded to the respondent employee. How many?
Only one.
Respondent employee for paracode of the insurance. Next one. Learned AGA, Mr. G, AGA appearing for the appellant. Kindly be seated. Vehemently argues that relief of the kind could not have been granted to the respondent employee in the face of the Odisha Group C and Group D posts into brackets, contractual appointment, bracket complete, rules 2030. First, he highlights that under Rule 5 of these rules, the posts in question attract only contractual appointment, and therefore the question of regularization would not figure at all. First. He tells us that this aspect of the matter has not been dealt with by the learned single judge. In WPC number 19951 of 2020, disposed of on 9/9/2021, on the basis of which the impugned order has been structured. And therefore, interference of this court is eminently warranted. First, he also draws our attention to application in I number so and so, supported by an affidavit, praying for condonation of a long delay of
67 days.
867 days. Next one. Learned counsel appearing for the respondent employee opposes the appeal, contending that there were sanctioned posts and there were vacancies. The appointment is made by the competent authority, and that his client does possess the requisite qualification and eligibility and qualification. First, he also contends that in the absence of lead decision being shown erroneous, by taking up specific pleadings in the memorandum of appeal, specifically in the memo of appeal, no fault can be attributed to the said decision. First, next. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter for the following reasons. Number one. Firstly, the appeal has been filed after broking a long delay of 867 days. Sorry. Learned counsel for the respondent employee is more than justified in opposing the prayer for its condonation on the ground of enormity of longevity of delay and absence of plausible explanation therefore. First, therefore, the application being devoid of merits is liable to be rejected, and accordingly it is. Next point. Despite rejection of the application for condonation of delay, despite rejection of this application, we undertake examination of the points canvassed at the bar. Next. It is not in dispute that there were posts and there were vacancies. Seven. The competent authority happens to be the local body. Corporation.
Corporation, municipality.
Municipality. It is headed by commissioner. No.
Executive.
Headed by the executive officer. Has he got power to appoint?
That is on as per rule, man.
No, we are asking you. He has got power to appoint.
Man.
Learned panel council appearing for the municipality very fairly tells us that the executive officer is the competent of authority to make appointment under the extant rules. Extant. First one. It is not the case of appellant that the respondent employee lacked eligibility and qualification when the engagement was done. First, obviously he does not. First, therefore, it cannot be gainfully argued that an employee appointed by the competent authority after verification of eligibility and qualification to the existing vacancy against the sanctioned post is not entitled to have his services regularized. Even state of Karnataka versus Uma Devi would not come to the aid of appellant, let alone the other decisions whereby march of law has taken, namely Chagu and Shripad. Next point. Learned AGS contention that under Rule 5.2,
that is a repeat.
This is repeat when?
In the year 2022. It's a case of regulation of service as per the GA Department resolution dated 17/9/2013.
It is as per the resolution.
Yes.
But these resolutions are repeat.
These are repeat.
When they are repeat?
In the year 2022.
But when the order is made?
Order is made in 2014.
The impugned order is made when?
21.
When the rules were in service, in force.
Yes, sir.
Yeah.
Yes.
Therefore, he is saying that. That is what contention that under 5.2 of 2013 rules, all ports would become attract contractual incumbency, and therefore regularization could not have been directed, is a bit difficult to countenance. Firstly, such a contention was not taken up before the learned single judge. And no explanation is offered before us as to why such a contention was not taken up. Secondly, learned single judge has followed the lead decision in WPC number 19951 of 2020, decided on 9/9/2021 by another coordinate bench. First, that decision is not put in challenge, and therefore it is deemed to have been accepted with no reservation whatsoever. First, it is also not the case of appellants that the fact matrix of this case does not match with that of the lead decision. First, no contra plea emerges from the appeal. First, government being a model employer as ordained by the Constitution, by the Bhupendranath Hazarika versus State of Assam, 2013, Supreme Court, etc., just look into the table. It cannot be selective and choosy. Within a class of employees. First of all. Next point. Even otherwise, the pleadings in the appeal have not been structured in such a way as would admit the plea that the lead decision itself being bad would not have been the basis for constructing the impugned order. First of all, the exceptions pointed out by the apex court as to when an appeal can an appeal challenging an order be laid without calling in question the lead judgment has not been established before us. First of all, admittedly, the litigant has put in more than a decade long service which is spotless. First time. If others have already been granted regularization in terms of lead judgment, there is no reason to show stepmotherly attitude for the respondent employee hearing. First time. In the above circumstances, this appeal being devoid of merits is liable to be rejected, and accordingly it is. First one, the order of the impugned order of the learned single judge shall be implemented within how much time it was given? 2 months. Within a period of 2 months. 2 months.
Only one submission, Your Lordship. But Your Lordship, the lead decision has not been challenged. The lead decision was challenged, confirmed by this honorable court as well as apex court.
We are told at the bar by learned counsel appearing for the respondent employee that the lead decision was put in challenge before in writ appeal number
777 of 2021, Your Lordship.
777 of 2021.
Yes, Your Lordship.
And the coordinate bench of this court
and Supreme Court order. Yes. And it was disposed upon agreed.
He is a tough opponent for this. That order is itself is lengthy. It weighs in, it is not 1 kg, but many pages. 28 pages order, writ appeal order.
Yes, and 51 pages single judge order. And learned single judge directed for personal appearance. Thereafter they have filed. Your Lordship, can you see in the content?
Mr. G, this you have not disclosed in your appeal. You mean
No, it is
whoever has drafted
yes, yes. It is not
sharp practice.
that I do not
If
know.
he had not brought to our notice, you should have said.
I'm also.
No, I'm not blaming you, but government has to pay cost. This is a very bad practice. You have suffered order at the hands of the learned single judge. Personal appearance of the officials has been ordered. Then matter is taken in appeal, and appeal itself runs into 28 pages. Then you carried it to the apex court. You suffered dismissal. Not even a sentence is said in your appeal.
In memo, it is not there.
Not so.
But this is not that case, but it's a different case.
Different, no. In this case, it is a writ appeal 300. No, that appeal is also there. This is the
280, writ appeal number 282 of 2024. 282 of 2024. Where present appeal.
no WPC 1995 of 2020. Para 2. Para 2 of the judgment.
Yes.
It is there. No, gee, your state should pay 1 lakh rupees cost to the employee. Whatever. Lead decision, lead judgment that runs into how many?
It's 28 pages. Lead judgment 51 pages.
It runs into 51 pages. Semicolon. It was put in appeal. Put in challenge in writ appeal number
777 of
2021 and other connected appeals. Other connected appeals also.
Yes. Right.
Other connected appeals. Semicolon. The coordinate bench of this court, while the judgment dated when?
These are part of the appeal memo itself.
Judgment dated 12/4/2023.
Yes, 12/4/2023.
Repelled the challenge and affirmed the lead judgment of learned single judge. First, matter did not stop here. Colon. It was carried further to the apex court in SLP number 17482 of 2023. And that also met the same fate, while the order dated.
Yes. The visual was taken up as the leading case.
Twelve 2025.
Yes. The visual was taken up as the leading case, Your Lordships.
Yes. 12/11/2025. Yes. Not even a word is whispered.
My lord, with the apology. These are all part of the records, my lord. We have annexed the that lead judgment of Patitapavan Datta Das case, as well as the order passed by your single bench judge dated 16/9/2021. These are part appeal memo. It is there, but regarding the order passed in the writ appeal, it is not there. Probably before that it was filed.
Writ appeal and SLP.
SLP it was not there.
Then we will not give it because it is part of the record. So they have not suppressed anything as such. In the above circumstances, the appeal being thoroughly devoid of merits is liable to be sent.
Great for you.
All right.
Passed over item kindly taken over item 7.
7? Passed over matter? Yeah.
Sorry, I could not present it.
How are you, Mr. Rao, now? Yes.
Item 7.
Yes. The petitioner is the purchaser, auction purchaser in a auction sale held by the bank, opposite parties in respect of a loan amount which was the borrower has lost, and the auction was confirmed. I have deposited the money and confirmation was there. You will also see annexure 3 at page.
Confirmation is done.
Yes.
You take notice.
Yes. Then what has happened? They have unilaterally cancelled it. Therefore, I am here.
So you take notice.
Yes.
It is not challengeable before the DRT.
No, nothing was done. It was confirmed in 2024 itself.
Issue emergent notice, returnable within 3 weeks. Yes.
I have said that filed an IA that they will not proceed further to again sell the property. They are now attempting to sell it again.
Cancellation they want to sell.
Not to create any third party interest again.
Learned senior advocate Mr. Rao appearing for the petitioner draws attention of the court to application in IA number so and so supported by an affidavit seeking interim protection pendent deleted. First, he apprehends that unless interdicted, the property in question is likely to be alienated or encumbered, and therefore protection is eminently warranted. First, we agree. Next, in the above circumstances, application having been favored, we direct the OP bank to retain the property as it is without undertaking alienation or encumbering the property. So it's a next state of it. Yes, still next state of it.
Item 13.
Yeah.
12 is adjourned. 12 adjourned. No. 12 I have not adjourned. It's a covered case. Yesterday's that matter 28 items serial. It is not covered.
My lord.
Covered by
Not so.
Not so. Yesterday's item number 28.
Yes, sir.
12 and 27. 12 and 27. Yes.
Item 13.
13, my lord. 13 also covered matter, I already decided.
Item number?
13, my lord. 13.
13.
Yes, my lord. I already decided the issue and
Let's show it too.
yeah, I have given. I have already given since long. Yes. That is also reflected in the order dated 9/10/25. I have served the copy. Sir.
Appeal also, SLP also dismissed.
SLP dismissed. Thereafter they comply the order. 15 persons. Others left out. They are not given. I approve my lord. My lord.
The others are before this court now.
Yes, my lord. They are under single judge relying on the judgment of appeals court, allowed the case. They are not given appeal. In the appeal similar matter, also dismissed the matter. That I given.
Not single judge followed any decision.
Appeals court.
Apex court.
Biren Mitra Frank case, yes. Also same issue had placed. Biren Mitra Frank case.
It refers to Karnataka High Court judgment.
Yes, Tribunal that High Court of Supreme Court, my lord. Same issue. That is, my lord. Last paragraph. In view of the above certain discussion, our consider opinion the direction issued in the Biren Mitra Swami case. Yes, last paragraph of the my lord's order.
No, this is Sheila Devi. The counting of prior service for purpose of terminal benefits.
Which period, my lord? Lordship. Which period they are counting?
No, Apex Court clarified that also.
Yes. No, my lord.
Para 9 of the judgment.
I have given that, my lord, para 9. I also include that of the judgment, my lord, para 9. The period work under the
which period?
against the regular vacant work on contractual basis, para 9.
Here.
Para 9. In the reply, I have also enclosed, my lord.
They were orders of various high courts.
My lord. I have not decided this.
Any order we have afterwards.
My lord, sir.
Any order is
Yes, that I have given my lord. Just not given my lord. The two copies I have given, just not given. My lord, sir.
The subject matter of this appeal by the this appeal it is.
My lord, appeal by state.
By the state is substantially similar to the one treated by a coordinate bench. A coordinate bench of this court in writ appeal number 2879 of 2024 between state and others versus Anand Chandra Das, heard and disposed of on 25/7/2025. Paragraphs in paragraphs 10 and 11 of the said decision, it is observed as under. Next paragraph. In the above circumstances, this appeal fails.
Will your lordship record my submission? My submission is that his initial appointment was under a project.
I think that is also considered
yes.
Judgment.
Yes, I have seen that judgment.
Not apex court judgment.
It is your lordship's judgment. That is under a project in the year since 97-98. Duly sanctioned in the vacant, that is in the ground itself, it is there.
Sanction post 2004.
Paramedical.
Upon 2004.
Paramedical worker. He was regularized subsequently thereafter in the year 2010.
Correct.
10. My lord, service shall be counted from the date he was regularized.
No, we
from
rejected that condition.
My lord.
Anyway, we should tell. One more sentence. That was before in the written. That was circumstance now. About that, you right. The vehement submission of learned HEA that in the decision in Anand Chandra Das, the employee was already regularized in service. And unlike the appeal at hand, and therefore that factor would weigh in favor of the appellant for interference of this court does not impress us. First one. That factor is not otherwise also not relevant. Delay control.
All are same. All the opportunities.
All are same.
Item 14. Item 14 and 15. Both the matters are identical matters, your lordships. Yesterday, my learned senior took time to take instruction whether the matter is covered by the one I was placing on. The one it was agreed.
It was your.
Covered. Which is that?
The one your lordship just reflected.
515 of 2020.
Patitha Baban Datta, your lordships. Patitha Baban Datta is very in direction was able to regularize 600 attended operators. That was in respect of Cuttack district, and this is with respect to Balasore district.
This is the serial number?
One, your lordship, that is 58.
14 and 15.
Yes, your lordship. Same.
It's a very well considered order, no?
Yes,
your lordship. Those two judgments were based on the judgment of Patitha Pavan Datta Das. And here, yes.
Patitha Pavana Datta.
Patitha Pavan Datta Das.
Datta Das. Datta Das. If Das, Datta Das, or another thing. The
extra copies.
Similar orders we have. We have already passed any order?
Yes.
Just now.
It was item 11.
So it is
Item 11.
That's order, your lordships.
11 means the one that you.
Yes.
Where you did not vote.
The subject matter of this appeal is substantially similar to the one in writ appeal number 777 of 2021 and other connected matters between State of Odisha and another versus Patitha Pavana Datta Das and others, heard and decided by a coordinate bench of this court, wide order dated, judgment dated 12/4/2023, whereby a learned single judge's order dated 9/9/2021 entered in WPC number 19951 of 2020 between Patitha Bhavana Datta Das versus State of Odisha and others has been affirmed. First, we are told at the bar that this matter was carried further to the apex court in SLP number.
I have given that order.
What is that number?
I have given that at the copy.
Yes, you know. Yeah, right now.
Yes.
No. Earlier you had.
No, earlier you
I have given just now.
That is item 11.
This is
just tell the SLP number.
SLP number is 5815 of 2024.
2024. Dismissed on in February 25.
11/25.
Plus 17482 of 2023.
SLP number 17482
of 2020.
17482 of 2023. Dismissed on
12/4/2023. Sorry.
12/4.
No.
No.
It's not.
Not 12/4/20.
No.
It is 12/11.
12/11/20.
2025.
In the above circumstance, appeal being absolutely unmeritorious, is liable to be rejected, and accordingly it is, courts having been made easy. One set is just, we may need one set, na?
I've already given.
Yes.
Along with the SLP order.
Delay is, then we will not condone delay also. The 900 or delay.
Delay is 921 days.
Not be condoned.
12/22 days.
This one is 921.
9/25.
Another one is.
Another one is
1,200.
Ah,
200.
that's a citation for delay. Just mention how many days? 1 to 2, 14 and 15. In 14 delays, 921 days. In 15, 1 to 2, 1 to 2, 1. Yes.
Grateful.
Okay. The order is implemented.
On the verge of being implemented, Your Lordships.
The impugned order of the learned single just to be implemented within 8 weeks.
Yes.
So, 10 weeks.
Grateful.
Both 14 and 15. Both. 14, 15 delay application, which is that also subject.
Grateful.
Filed withdrawal memo. We
What
pray to
withdraw?
Yes, ma'am.
Have you filed memo now?
Yes, ma'am. We have already filed.
That is in the noting also.
Yes.
Memory itself. Yeah.
Grateful.
One pass of that. Item 10.
May I please, Your Lordship?
Yes, Mr. Mukherjee.
The short question that falls for Your Lordship's consideration in this case is that after accepting my restructuring plan and having acted upon it, can the bank on the very next day issue a notice under section 13(4)? That is the question that falls for Your Lordship's consideration. I'll straightway take Your Lordship's.
But you have alternate remedy of going before the
My Lords, here it may not work. Kindly bear with me for 1 minute, my Lords. Kindly come to page 114.
Yes. That judgment which said the Great Court can exercise even in bank. A Lotus Group of Hotels versus. Take out Lotus Group of Hotels versus Gujarat State Finance Corporation.
Gujarat State Finance.
Gujarat State.
Yes, yes.
Even in loan matters, Great Court can exercise jurisdiction.
Yes, my Lords, where there is stark contradiction in the action of the.
Not essentially contractual, but if it got some elements of public law, then we have.
Absolutely. I'll come to the public law aspect later on. But let's kindly come to page 114. This is an email which was sent.
Let them verify. You appear for the big.
I'm
having accepted restructuring.
That I have to verify.
That's what. That's what. You just verify. Take notice. And don't precipitate the matter till next date of hearing. What is the amount involved?
Must be 62 crores was the 13-2 notice.
Yeah.
The now outstanding between the 13-2 notice and now the outstanding is 50 crores. So 12 crores I have paid up in the meantime. 25 lakhs in terms of the restructuring plan has been paid yesterday. This is the receipt. This is not after the writ petition was filed.
On the basis of your claim in 13.2, demand notice.
Yes, 13.2, after 13.2 notice was given, there was a negotiation. They called me for negotiation because my account is of 1981. But I am constructing transmission towers, not only in India, but also...
So your reply is for reconstruction and this.
Reply is, and that was accepted by them, and that is at page 114.
They accepted it. Next day they issued 14.2.
13.4.
13.4.
Yes.
So it is MSME, how could you?
You just verify. We'll call this matter tomorrow. Where from this? Where
from Calcutta. Calcutta, I have to take. Though branch is Baleswar, but there is a plant is there who are 10 crores above. He is looking after from Calcutta. I have to take the instruction from the Calcutta.
Emergency notice. Learned panel counsel Sri so and so on our request accepts notice for OPs, all OPs.
They should, yes, it's only the banks.
Yes, all OPs.
Yes, all of us.
Don't precipitate the matter till next date of hearing.
That's IN number 212.
Day after tomorrow, let it come.
Yeah.
Not on Friday.
Monday.
But Friday I'm not there.
Day after tomorrow.
Monday. All right.
And I'm serving the copy on him right now.
Yes,
Your Lordship. Record that.
Yeah.
Item 16.
Item 16, kindly one Passover matter. Mr.
Passover. Yeah.
Item 17.
Yes.
My lord, this there are two writ petitions. One is, your lordship, the presently arising, this arises out of that. 13334 was 3/4/2024 is the present writ petition. And another writ petition was there, which is subject matter of, my lord, writ appeal number 854. 854.
Not posted today.
Not posted today.
We'll call that also.
Here condonation of delays and substitution, those problems are there. Reason being, in 16,405, your lordship, if you, my lord, looks at page 45, in fact, page 62, 63, my lord. Tirlochan Jena, serial number 3. My lord, he had died and he was substituted. Yes. On the date of disposal of the cases, my lord, when these were taken up, 13334 of 2024 was also taken up, out of which the present writ appeal arises. Here, my lord, he has not substituted.
No application was filed and it was allowed.
No, he had not filed also. So it was disposed of on that day. I had no occasion to know also that he has not been substituted. Now what happened? I filed writ appeals against both the cases. Because one common order that is at page 45, I filed 2 appeals. In this appeal, later on I find out that that person has died. Now I am to substitute him because that decree order is against a dead man. And clearly, lordship. So accordingly, I have filed these petitions, condonation of delay, substitution, and setting aside abatement.
Let notice go.
Yes, your lordship.
Issue emergent notice. Both on appeal and applications. Yes.
Let me be connected with 754.
Call along with
75424.
Writ appeal number.
Writ appeal number. 854, sir.
He died before the judgment was passed or
before that, because this substitution was earlier. Effective decision.
Yes.
Item 18.
He died in 2019, 10/11/2019. Yeah.
Item 18?
18, my lords. This is similar to yesterday there was a matter, writ appeal number 160 of 2024.
Identical.
The Lordship.
Your Lordship already delivered similar judgment.
We followed this judgment
My lord.
in that.
It was, my lord,
No. My lords, that is not uploaded. I was.
disposed of on 12/1/2020.
The other one yesterday.
Exactly. Actually, I'm giving that judgment.
Your Lordship, the same, the verbatim the same, substantially the same, because para 7, para 9.
Yes.
Your Lordship has quoted para 9 in this.
Do you remember that serial number? Yesterday's serial number?
20.
My lords, that was writ appeal number 160
28
of 24. Item 16 or something.
But this case is exactly similar.
Similar. It will be dismissed.
Not dismiss it. The exactly same. The only party name is different and but dates are different.
In today, which you have given now?
No, yes. Today we have given now. Because Lordship did allowed this was of it on 975. The batch of applications are filed and 7-8 applications are still pending. Data appeals are still pending.
The subject to the state is in appeal, grieving against the order dated so and so, entered by learned single judge in WPC number dated 15/4/2024, entered in respondents WPC number 8882 of 2024, whereby relief has been afforded in the following terms. The subject matter of this appeal, any delay and other things?
Delay is there.
How much?
My lords, 373 days.
The appeal is filed after grouping a long delay of 373 days and an application supported by affidavit number so and so accompanies the same. Explanation is offered. It is found to be plausible and therefore application deserves to be allowed. First time. Accordingly, the same is allowed and delay is condoned. Next time now. Learned senior advocate Mishra appearing for the respondent employee submit, and the learned AGA does not much dispute that the subject matter of this appeal is substantially similar to the one in writ appeal number 975 of 2025 between Principal Secretary to Government versus Government and others versus Ashok Kumar Bhattanayak. Heard and decided by the coordinate bench of this court by the order dated 12/1. No, by us, by order dated 12/1/2026, whereby appeal is dismissed. First time. Similar cases need to be treated similarly in the norm of adjudication. First time. Next, in the above circumstances, this appeal also being devoid of merits is liable to be dismissed and accordingly it is. First time. The order of the learned single judge shall be implemented within an outer limit of 8 weeks, and a compliance report shall be filed with the Registrar General of this court in 1 week next following. Failing which contempt action will follow.
Much obliged.
No cause. Yes.
Item 19 has been
Assisted by Mr. D.K. Patnaik.
So assistant, please.
Much obliged.
Item 19 has been disposed of. Item 20.
Yes.
Ultimate Lord, it's a state appeal. challenging the order.
Any similar matters we have decided?
Similar matter, in fact, it was discussed in serial number 11. Today's list before lunch.
That contractual.
That's contractual. But,
Identical matter.
but I want to point out one point.
In fact, not identical, to some extent it is
To some extent. But so far the discussion and academical part is concerned, I can put only 2 points. The state government has taken a decision in 1905-2010, my lord. Abolition of base level regular post, my lord. Against that, with kind concurrence of the Department of Finance,
yes,
they want to create this contractual post.
That 5-2, rule 5-2.
Yes, ma'am. And if I glance to 19.5, that is at it is at page 10, my lord. In the writ application, so far the counter is concerned, that I have filed, it is in the application. Abolition of 71 numbers of post. Here it is gardener, my lord. So far the petition and the writ application is concerned. In different offices under the Directorate of Horticulture, Odisha. This is a letter of the Additional Secretary. I am directed to convey the sanction of the Governor for abolition of 71 number of sanction posts of the gardeners of 45 offices under the Directorate of Horticulture.
These are all gardeners.
Gardeners, man.
The very same posts which have been abolished. Are they working against those posts?
Yes, ma'am.
Is it true?
No.
Not true. How many sanctioned the strength of these gardeners posts? How many?
71.
71. All posts are abolished.
Yes, ma'am.
When were they abolished? 2010.
Yes, ma'am.
Where is that also?
That is at B/2 to my counter, which has been filed in the writ application, my lord.
Since how long these people are working?
Since 2010.
They are working since 2011.
Sir, 2011.
2/12/2011.
Whether that point was canvassed before the learned single judge?
Yes.
That
has not
discussion.
My lord, though I have agitated in my counter, but this it is not reflected in the judgment, my lord. It is at page 2, my lord.
Page 2.
As seen, judgment of the honorable single judgment.
Then you go for review. If a particular, the Supreme Court says, if a particular point is already taken up in the objection statement,
yes, that is not
or pleading, and the same is not treated by the learned single judge, then it is a ground for review. Why appeal? And appeal is against treatment of the subject by the judge.
Yes.
If a particular subject is not treated, where is the question?
It has not been taken care of, my lord. I want to point it out, my lord. I thought it proper to point it out.
No, that's all right. We agree. Because it's a law is settled. Right from 1946 Federal Court. Federal Court said the Order 47 Rule 1-2. And there is one more point, I think 3, which if a particular point is not urgent and not treated, then the way is to go for the review. That is the ground. Only then we will have right of appeal. We have to judge the view taken by the court below.
Taking into consideration all these aspects agitated by the parties. Yes,
we don't have the benefit of that view. Therefore, no appeal against that.
May I clarify? I have read the
Any other ground you have?
And apart from that, without taking that aspect, the order of regularization so far this
contention is taken up in the counter.
Yes, ma'am.
Your Lordship, what is the counter?
Yes, ma'am.
I have given that copy of the agreed
Have they taken in the counter or not?
In the counter, they have taken the stand.
Yes.
71 posts are abolished
and 71 posts are created on contractual basis. Out of 71 posts, 12 posts are advertised, and on the basis of advertisement, a selection procedure was done. And on the basis of that selection, we are appointed.
You are appointed to contractual.
On contractual basis. I have relied on that their notification.
There is a system that a consolidated amount of rupees 5,200 will be paid monthly.
5,200.
Yes, ma'am.
Is it not less than
2010 million.
minimum wages?
It is in 2010 million. Subsequently, it has been revised. It is in 2010 million.
Basic pay of a group C employee at that point of time. That is minimum. I have relied upon their resolution 79/2013. Look, I have also annexed to the writ. I have given the copy of the writ petition and also counter.
It had come today in resolution under 309 and again.
No. Resolution is not under 309. But there is a difference that I will clarify. That.
Rules are under 309.
Yes, rules are under 3. Rules are under 309, and 309 rule is that contractual appointment rules is different from resolution that is 79/2013. 79/13 resolution speaks regularization of contractual employees. 2013 rule speaks from 17/11/2013 all regular posts will be abolished and contractual appointment will be made. So this is a resolution for regularization of contractual employees who are appointed on abolition of regular post on creation of contractual post.
So that will be not be available at all. That ground itself will not be available is your contention.
Yes, but that they cannot say because these posts are for a moment that is for that resolution. I have annexed that resolution. At page 15 of my read petition. 15. Yes, ma'am, of my read petition. I have handed over.
It is at page 15.
This is 17/9/2013.
Yes, ma'am. 17. May I read, ma'am?
Yeah. The relevant portion only.
I am only relevant to the second paragraph. Second paragraph only.
The policy regarding.
Yes, ma'am. Contractual appointment, public engagements made against contractual post created with the concurrence of Finance Department on abolition of the corresponding regular post or contractual appointment made against the contractual post created with the concurrence of the Finance Department without abolition of any corresponding regular post in case of new offices or for tendering of the existing offices services following the recruitment procedure prescribed for the corresponding regular post and the principle of post and services for different reserves. If these contingents are right, then on completion of 6 years, they will be regularized. The next page, regular appointment.
Rule 1.
Yes, ma'am. That is the not clause.
Regular appointment.
Yes, ma'am. That is clause 1.
Clause 1.
This is the resolution.
Paragraph 1.
Ma'am. Paragraph 2 yellow. Paragraph 2 is
on regular appointment.
Ma'am. On the date of satisfactory completion of 6 years of contractual service or from the date of publication of the resolution, whichever is later, they shall be deemed to have been regularly appointed.
Deemed to have been regularly
appointed? Yes, ma'am. That deemed to be regularly appointed from the date 17/9/2013 if he has completed 6 years on 17/9/2013. If he has completed 6 years thereafter, when he completed 6 years, he deemed to be regularly appointed. And your lordship may, for a moment, your lordship may see the annexure 1 of my read petition.
Mr. Mohanty.
Yes.
This resolution is relatable to
2013.
No. 2013 is relatable to Rule 5.3 or 5.2. 5.2.
Yes.
Kindly see Rule 5.2.
That is the rule.
Yes.
Contractual appointment rules, because I answered it when G was arguing the matter.
Yes.
5.2 provides for the government issuing any orders, notification, circulars.
Yes. Recruitment procedure.
Recruitment procedure. 5.1 travel to 5.2.
notwithstanding anything, contended in the relevant recruitment rules or executive instructions.
Yes.
As the case may be in force, all appointment made pursuant to Rule 1 shall from the date of commencement of these rules be on contract basis.
Basis. Then there is another clause.
Rule 9, perhaps Rule 9. Total 6 years on completion.
No, government can issue executive instructions.
That is on 162.
Right? No, it does not travel to 162 at all. Because pursuant to 162, promulgation. Don't be distracted. They will get distracted. Under 160, now, even that question is academic now. Because already rules have been promulgated. If that is so, how you are going to...
For a moment, for academical manner. I am reading 7 September 2013 rules, 1 second. Man.
Rules?
Yes, ma'am. That resolution. I'm sorry.
Resolution.
Yes, ma'am. Which my learned friend is reading out. The contractual appointment, may I read it? 3 riders are there. The contractual appointment oblique engagements made against the contractual post created with the concurrence of the finance department.
This is only a preamble.
Yes, and abolition of the corresponding regular post.
Also part of
that also happens. My learned friend has read that earlier in his counter. Post
created with concurrence of finance with abolition of any corresponding regular post in case of new offices or strengthening the existing offices, service following the recruitment procedures, my lord, prescribed in the corresponding regular post and principle of reservation of the post.
Where is the verb in this? Where is the verb?
Verb. I will clarify that.
This has not been done.
Let me see the section 3 of Warby Act. Section 3 of the Warby Act says this is not applicable to contractual appointment.
Which is not applicable
to contractual appointment.
Warby rules is not.
Warby Act.
Warby Act.
Warby Act.
Reservation of vacancies.
Vacancies Act.
Regularization.
No, reservation of vacancies.
Reservation of vacancies.
Act.
How they are not considered? It's like
that they are saying Warby Act, following Warby.
No, I am not on that. I am asking, I am on grammar.
Grammar, verb.
Verb, noun.
Where is the verb?
Noun. Preposition.
Here, where is the verb?
Where is the verb? It is
That where
therefore, it is not a rule. It is not a paragraph. It is only intent.
Yes.
It becomes preamble.
Preamble. And my lord has shown my lords that creation and has shown that abolition. Your lords may say that in that counter, I have also given that counter copy, my lord. Your lords may say page 10. On the counter, no, counter is there.
Page 10 now?
Counter. That has not been numbered, my lord. They have given that copy. I have given just that annexure B by 2 series.
That is 19/5/2010.
19/5/2010.
Yes. It is B by 2 to my counter.
Creation of 71 number of contractual post of gardener for different offices under the Directorate of that is the document you are.
This is abolition.
That is creation.
This is creation.
Yes, creation. Next page, abolition.
That is also 1905.
Yes, posts were created on a regular basis. That was abolished to fill up those posts on contractual basis. And that resolution speaks that
posts are
regular posts are
it is not abolition of posts. Posts will be there.
Yes, posts will
be
contractual nature.
Yes, my lord. Nature of the post was changed.
Correct.
And all these matters and similar matters your lordship have already decided, and it has also similar cases has gone to Supreme Court. Honorable Supreme Court
rejected
yes,
SLP.
Yes, ma'am.
Once SLP is rejected.
No, my lord, that I don't have a knowledge that one.
They do. Public new.
Why you are, Mr. Mantri, you are not briefed properly in all these matters. The same department does it or some other?
Same gardener. In those cases, my lord, they have not faced the interview, we have faced the interview. That is the difference only.
But that was dismissed on the ground of limitation.
Honorable Supreme.
No, if SLP is dismissed on the ground of limitation.
Yes, my lord.
Order of the High Court is not that it is confirmed.
Yes, my lord. That I have just brought to my lord's notice that similar. And on merit, I have shown, my lord, that Honorable Single Judge has said, as he has completed more than 10 years of service, and I facing the recruitment test, in view of the judgment of the, in case of Uma Devi, his case may be regularized.
No, you were reading one particular rule which says they shall be deemed to have been regularized.
Yes, that is also in favor of me. But Honorable Single Judge relied upon that judgment of the Honorable Supreme Court.
No, it says 5 years. Uma Devi says 10 years.
10 years. It is
Uma Devi says 10 years.
Then why 10 years? If rules say 5 years.
6 years.
6 years.
Yes, ma'am.
Now that repeal. Now resolution.
This is not repealed.
But this is your appointment is in 11.
This is in 11.
Yeah.
That came in 2013.
But that will take care of them also. Because 5 years will be, 6 years will be over.
6 years.
After the passage of that. So obviously these rules will be applicable to them also. Even otherwise, Uma Devi will be helpful to them, which you should have taken benefit of. It does not come to your rescue because there is a post, there is a vacancy. Competent authority has appointed. They do possess the qualification. Even they fit into
without any interim order, courts.
Without interim order, they are continuing. So within the parameter of Uma Devi also.
But my lord, so far this finance department concurrence, reservation rules, and the recruitment procedures. These are the three things which is available in a 2013 resolution. That is my all the way stand in my counter.
Oh, how does it affect him? It is the strongest case for regularization. Strongest case for regularization because
I am not standing on them. It is my duty to point it out this thing.
We are only
at the threshold.
This one. I appreciate whenever you raise your voice to protect the purse of the state or you hold the sword of the state, we agree with that. But point is, even within the parameters of Uma Devi, their case fits into. Let alone ML Kesari, Jago, Shripad, you forget them. Even within case in Uma Devi it comes. A sanction posts are there. Vacancies are there. They possess the qualification. Competent authority has appointed.
And face the recruitment test.
And they have faced the recruitment test. One more point, which Uma Devi did not consider.
Irregular and illegal.
Nothing. There is nothing. Take up. The state and its officials are preferring this appeal agreed by the learned single judge's order dated 4/12/2024, whereby, which is your writ petition?
My writ petition 27900 of 2012.
Respondent employees WPC number 27897 of
27900. 27900.
27900 of 2021, having been favored. The following relief has been accorded. Mention the learned AG appearing for the appellant. Kindly be seated. Appearing for the appellant fervently submits that learned single judge brought the error in according the relief of regularization in terms of the decision in state of Karnataka versus Uma Devi 2006 for SCC 1. 7. He also points out that all posts having been abolished by the government resolution dated 19/5/2010, the regularization could not have been directed at all when contractual appointment was the mode of engagement. First time. He also draws our attention to Rule 5(2) of which are those rules? Of
Orissa contractual Group C and Group D employees.
Just write down and write down. One second. The Odisha Group C and Group D post contractual appointment into brackets, rules 2013. First one. Learned counsel appearing for the respondent employee makes submission in justification of the impugned order, contending that the case of his client is a textbook case for regularization in terms of Umadevi, even if a ratio in Jago and Shripad is not invocable. First one. He also draws our attention to the resolution dated 17/9/2013, which was a part of record before the learned single judge to countenance his submission that in terms of paragraph 2(1), his client is entitled to regularization after the completion of 6 years, as distinguished from a period of 10 years contemplated under the Umadevi. First one. He adds that posts, there exists the posts, sanctioned posts. There exist the vacancies in the posts in question. There was a public advertisement pursuant to which his client state claim for engagement. Competent authority after verifying the credentials as to eligibility and qualification has engaged to engage. First one, at this length of time, denying the relief of regularization to be very unjust. And therefore, appeal of the state should be dismissed. First. Next, having heard learned counsel for the party that having perused the appeal papers, we are of the considered opinion that the subject matter of this appeal is substantially similar to the one in W appeal number.
That is WA number 3019 of 2013.
3019 of 2013. Heard between
case Coben state that state of commissioner cum secretary to government of Odisha and another versus Kobendranath Sahu and another. And arising out of WPC OSC number 2629.
Disposed of by a coordinate bench of coordinate bench.
Yes, ma'am.
Coordinate bench of this court by the order
18/12/2023.
2013. 2022. First one. Similar cases should be decided similarly is the rudimentary principle of adjudication. First one. The said order was carried in SLP number. That is the one?
Yes, ma'am. Yes, ma'am.
SLP number. SLP diary number
34606
of 2025. And the same came to be rejected on the ground of delay. Why the order stated
25/11/2022.
First. Therefore, this appeal also has to meet the same thing. Next slide. Learned counsel appealing for the respondent employee pressing into service rules, which is that rule? 6 year.
That is resolution.
The resolution, paragraph 2.1 interpretation 2.1 of government resolution dated 17/9/2013 contains that whatever. Contains that the regularization is by a deeming provision. Once an employee, contractual employee, has put in a service of 6 years, and the benefit of this resolution needs to be granted to his client, who has been appointed
on 2/12/2011.
On 2/12/2011, need not be gone into because he is not in appeal against the order of learned single position. Next one, in the above circumstances, this appeal being devoid of merit is liable to be dismissed, and accordingly it is, costs having been made is.
Let me add one line that 217 days delay, that may be condoned. Delay is there.
We have to update.
One prayer. Order to be implemented.
The order of the learned single just to be implemented within an outer limit of 8 weeks, and compliance report to be filed before the Registrar General of this court within 1 week next following, failing which the erring officials run the risk of contempt action.
Item 21.
May Your Lordship, I'm on the virtual mode, Your Lordship. Item 21.
Yes.
Your Lordship, 44 days you delayed, maybe condoned, is obscured due to the time consumed consultation of the council and preparation of appeal. May be condoned, Your Lordship.
You are for
I am for the bank.
And for the appellant.
Appellant borrower.
Not borrowed, auction purchase.
Auction buyer.
Auction
Your Lordship, Your Lordship, read petition was dismissed on the ground that matter is pending before the DIT. Without appreciating that the subject matter, the read petition is completely distinct from any DIT proceeding, Your Lordship. Your Lordship, my prayer was simple direction to the bank CDA letter, maybe comply. The single judge did not consider my application. Fact is that, Your Lordship, the read petition was filed by the appellant seeking a limited direction to the respondent bank to comply with the official communication. Annexure 3, Your Lordship. Simple prayer. But Honorable Court dismissed on the ground the matter is pending before.
You are probably not able to hear us. What was
that I have to take? What he's telling that I have to take instruction.
No, it appears learned single judge has grossly erred.
But that I don't know. Let me give a supply a copy and then I can take instruction.
This is our first time notice.
First time. Please
issue notice. Learned panel counsel Sri.
May Your Lordship, may audible?
You are audible, but we request you to keep quiet. Learned panel counsel Sri. So and so on our request accepts notice for OP number, respondent numbers 1 and 2. First up, appeal is filed after booking a short delay of 44 days, and an application is put by affidavit in the same. Explanation offered is found plausible, and delay is very short. First, Therefore, application is allowed and delay is continued. First, call this matter week after next.
Week after. Let me supply a copy of the.
Call this matter week
Your
after.
Lordship, maybe time may be fixed, Your Lordship. This matter already filed in November 2025. Listed may be very difficulties.
Petitioner appellant to furnish a copy of the bill to the panel council immediately.
Your Lordship.
Item 22. Item 16.
Obliged, Your Lordship.
116. Both the lots are available. Please come.
Item 16.
Minus.
Lord, in this case,
yes,
the order of the Hon'Ble Single Judge is under challenge by the management of the governing body of that institution, wherein my lord, direction is issued to us to give an appointment, a regular appointment to a person who was terminated in the institution in term of his appointment because it was a part-time appointment. He was initially appointed on part-time basis.
Appointed when?
Appointed, my lord, this is a checkered history. He was initially appointed sometime 94, continued up to 96, 1.5 years, 1 year and 3 months. I will give the list. Thereafter, his services was terminated because there was no requirement of part-time lecturers. See, he is the director, and the director passed an order in his favor in 2006, which was under challenge before this Hon'Ble Court. And this Hon'Ble Court directed that he implement the director's order. Director stated that they registered in the same office. So again, on 2011, she was again in pursuance to that order, given a fresh appointment on part-time basis, part-time lecturer. That she has accepted. And because all the classes were closed sometime in April, closure of the session, the academic session. So they terminate all the part-time lecturers. Against that, instead of going to the appeal or something, he has filed a writ application here in 2011, again challenging that order of disengagement.
That was a part-time, that was a stopgap arrangement.
Yes, only part-time. That my lord will find the appointment order for page 43. Annexed.
You were not a party before the.
Yes, the governing body was a party, but before the Hon'Ble Single Judge. Yes, they were there, but they could not file a counter. They could not contest the case. Because they contest in this, and they have their advocates, but they could not file a counter.
Then what we have to do?
No, what my respect submission is, my lord, of the judgment. The Hon'Ble Single Judge has directed you give him a regular appointment, which we cannot, my lord. That there is a bar.
Why did you not file the counter?
Pardon me, lord?
You should have filed the C.
Yes, that's true.
Lines would be drawn.
That's true.
File the counter.
That's true.
I have not filed.
I cannot.
If you come and complain against the learned single judge, what we should do?
No, only my respect submission is when this part-time appointment order he has not put. Only the disengagement order. And the Hon'Ble Court has not taken note of this aspect of the matter, whether we have filed a counter or not, my lord. This is a part-time appointment. So therefore, at best, my lord, in the worst scenario, my lord, we could have accommodated him as a part-time lecturer. Suppose the management has the fund and all these things. But this is a purely aided college, man. For the aided college, man, there is a rule. We are governed by a rule. The rule prohibits the private management to appoint staff, any staff in the institution, because all teaching staff has to be appointed through a state selection board. There is a board constituted by the director. And there is also
all this story you are telling before.
These are the
told before the
my respect submission only, my lord. This is a point of law only. Only with regard to the appointment.
The law does not operate in vacuum. It operates on facts.
That's correct. But kindly see the only shall I read, my lord, the last paragraph of the order. Kindly see, man.
Right of appeal is very, very restrictive.
My lord, I know.
That is scope of appeal is restrictive. Though you have right of appeal under because statute gives it. the scope of appeal is restricted, where you have not filed the pleadings.
But the Honorable Court has taken note of this fact that he was a part-time lecturer. Only two paragraphs I will read, page 63, the impugned order. Paragraph, page 63, paragraph 12 and 13 I will read, madam. Kindly see. Shall I read, madam?
On regular basis, it could not have ordered is your conduct.
That is well difficult. I am reading these two paragraphs, madam. Kindly see, madam. For the foregoing reasons, therefore, this court holds that action of the college management in terminating the service of the petitioner by treating him as a part-time lecturer cannot be sustained in the eye of law.
Why part-time the learned judge does not agree?
See, the court has taken note of the earlier order in 2006 by the director, wherein direction has been given only to reinstate him. There is no direction that whether part-time or full-time.
What was it earlier?
The order is director's order, which was earlier, that is at page 33, Annex 4.
33.
Yes, that is on 19/6/2006. And my lord, the order in question, that is the order of the director. If I'll take my lord to page 36, last paragraph. Last two paragraph. The scrutiny. Shall I read, my lord, the last two paragraph? Page 36. The scrutiny of the letter dated so-and-so, submitted by the principal, Ispat College, Raupala, and verification of the record of the college and the detailed report submitted by the principal in OJC number so-and-so, filed by Vijay Kumar Pradhan, and it transparent that the petitioner, Sri Rameswar Prasad Mishra, has been denied natural justice, although they stand on the better footing from all respects. And also, when the Honorable Court has directed Miss Case number 7 to keep one post vacant till disposal of the petitioner, there was no bar on the part of the principal to appoint Sri Mishra as a lecturer in physics. Therefore, without prejudice to the claim of others, the principal cum secretary, Ispat College, Raupala, opposite Patna 4, is directed to reinstate Sri Rameswar Prasad Mishra as a lecturer in physics within 1 month from the issuance of this order.
Does not say part-time, etc.
Nothing. But this was a part-time. There the management had contested.
This order was passed when?
2006.
Whether it was passed behind your back or it was passed after?
This was heard by the parties. It was disclosed to the director that he was a part-time lecturer. But what he has said is,
rightly or wrongly, this order has attained finality.
Correct. There is no dispute.
Therefore, writ petition was to implement this order.
What the Honorable Court has directed, give him an appointment.
Correct.
So that was given. She was implemented. It was implemented.
It was implemented, rightly implemented.
Yes. There is no dispute. We are not coming there.
Now, what was the prayer of the petitioner? Writ petitioner.
Writ petitioner came up. He has accepted the appointment which was issued to him in Annexure 6. That is, and submitted the joining report also pursuant to such appointment. As a part-time lecturer.
The order which you have read.
My lord.
The order which you have read now, that order is by the director.
Yes.
Director of
Higher Education, Orissa. That was implemented on 11/3/2011 after disposal of the writ petition.
That order dated
11/3/2011.
No, not
this order. 19/6/2006. 19/6/2006.
This order was implemented on
11/3/2011 by issuing another appointment order after 2 rounds of
11/3/2011.
Page 43. Annexure 6.
It was implemented on its own, or they, for implementation also they had come to court?
Because there are two writ petitions. Yes, that is right. Yes, there were litigations from 2006 to 2011.
This 11/3/2011 order.
He joined.
This order came to be passed because of intervention of the court.
After the cases were over.
We are asking you, was there a direction to implement this order? There appears to be. On your own, you would not have, because of
no.
2000.
Yes, it cannot be.
So naturally, 5 years you have taken because there was a court case.
Yes.
You did not implement. You implemented pursuant to direction of which, in which court?
After this honorable court.
WPC?
WPC, my lord.
111,663, my lord, of 2008. Again, file a review. 111,663 of 2008. I'm giving the judgment. Order, man.
This was decided when?
This was decided on my lord, on 1/7/2009. Here, my direction was given to implement.
Yeah.
Then your review file, my lord.
Implement.
Then review file. That is the number 249 of 2009, my lord. That is my division bench, my lord. Let me indulge your lordship, my lord. That writ application 2008 was disposed of by division bench. Yes, my lord. And review was also filed before the division bench.
Review number?
Review number is 249 of 2009.
RW?
Out of the writ application.
RWPET.
RVWPET number 249 of 2009. Then a plea was that no vacancy, therefore that was turned down.
Slowly.
I'm sorry.
You are in the top gear of the vehicle. 249 of
2009.
Review was filed by?
Review filed by the government.
Appellant.
Government.
That was the negative down?
11/1/2011.
Was it further carried to apex court?
No.
Implement. That was implemented.
Yes.
Implemented. They've given the appointment. On 11.
On what grounds you had sought for review? On the grounds that a part-time, etc. Now you are asking.
Yes, all these things. No, I don't have the reply. Was not the
Very
council.
interesting note, my lord. They have given appointment thereafter, after the lordship several orders, appointment for 7 days. They again terminated.
No, it's all right. That, do you have order dated 11/1/2011 with you?
Yes, my lord.
All the review order? Is it a considered order or just review?
No, considered. Even the very position is vacancy position was taken to concession review application.
No, nature of appointment, part-time or full-time?
That has not discussed specifically, but they have stated, let's take a look at two orders, my lord. This is the first order. The order division bench passed.
Okay.
Then is a review filed by the management. That both writ applications, one filed by me, one filed the management, challenging the order of director. Challenging of the order of director, the management approached this your lordship in that writ application, in one writ application. In another writ application, I approach, you implement the order of the director. That was decided in 2011.
There were two petitions.
Right petitions. That will get from the order itself, from the above manner. Then a review. Then it was directed to comply. Then they complied for 7 days. Again terminated. Single judge. Honorable single judge discussed everything. If you lordship read para 8, 9, 10, only lordship can look at para 8, 9, 10 of the improved judgment. Sum of the honorable single judge, sum of everything. And literally said that injustice has been denied. After 30 years, the order of the court has not been complied with. This is disrespect to the court. They have implied this statement, what I understood.
After these petitions and review, now the present order is what?
That order was implemented by the governing body by the order dated 11/3/2011.
11/1/2011.
March 11/3/2011. By the governing body, by issuing an appointment order in favor of the respondent.
Appointment order was issued on
11/3/2011.
That is after the dismissal of review.
A review and all this. That was on
Now
top
what
of
are
this.
you challenging?
Yes, madam. That what happened? 11/3/11, he was again appointed on this part-time basis. What is originally there? This appointment says accepted and joined back in duty. After that closure of that particular, what happened, my lord, here in this state, my lord, up to April there was classes. Thereafter no classes. We have to pay the salary from their own fund, college fund. The government never pay anything to them. So in April they terminated all these part-time lecturers because it is for a session.
No, she is not part-time at all.
Because the original appointment itself is part-time, man.
We do not know. Thereafter, so many things, so many bridges have fallen down, so many rains have fallen on the ground. We do not know. See,
He never objected to this appointment.
That's not the question. Whether he objected or not is not the question. It's called estoppel in pias, because it arises because of the record.
My response submission is at this juncture, my lord, in all the earlier writ petitions or everywhere, the governing body case was it is a part-time appointment.
It was never accepted.
It was not accepted only in this present impugn order.
No, even earlier it was not accepted.
Earlier it was dealt with because only earlier writ petition, what the Honorable Court has said, only implement the director's order.
It said grant regular appointment.
No.
Director's order. Kindly see the director's order.
Yes, ma'am.
You had challenged and you failed.
No. Yes. What the director says, therefore, without prejudice to the claim or claim of others, the principal cum secretary Ispat College Raukla opinion number fees directed to reinstate Rameshwar Prasad as a lecture fees within 1 month from the issuance of this order.
But
to reinstate
say in a part-time position.
The position he was holding, we have reinstated him.
Yeah, that word is missing in that order.
But that appointment he is accepted, my lord. That is the point. And when then they process like this, my lord. When we have terminated his service, again on 21/4/2011.
Dismissal with court, heavy courts. You are already troubling there.
And that appointment was challenged. And the Honorable Single Judge in paragraph 12, what it has held, kindly see, man. Paragraph 12 and 13, paragraph 63, the impugn order. For the foregoing reasons, therefore, this court holds that action of the college management in terminating the service of the petitioner by treating him as a part-time lecturer cannot be sustained in the eye of law. Resultantly, the writ petition is allowed. The impugn order under Annex 12 is hereby quashed. The opposite part number 3 is direct.
You have to appoint.
Pardon me?
You have to appoint her on the.
Yes, no. Hereby quashed. The opposite part number 3 is directed. Issue the order of appointment in favor of the petitioner on regular basis without any further delay, and in any case not later than 2 months from the date of production of this aspect of this order. So now the court has said that you appoint him on a direct basis. Now kindly see the provision of law. What the court says.
All that we will not see now because you should have raised all that points when you had challenged the order of the director.
That was
order of the director came to be. He wanted implementation. You wanted its widening. Widening was rejected. Implementation was directed. That order does not use the word part-time. Nowhere.
Our challenge is to the appointment of the reinstatement order that is directed by director only on the ground. Look here, he was appointed on a part-time basis. So we have no work now. We have no post required. So we have
rejected.
The court has said that there is
no director also said.
The director says since you have not followed the principle of natural justice, so that is wrong.
It is not a case of remand. It is not a case of remand.
No.
On the ground that natural justice are violated, therefore give him an opportunity of hearing and pass the order. That is not the order.
Correct.
The director passed an order which was formidable and unavoidable. And your challenge failed.
That's true.
He succeeded in his writ petition in seeking implementation of that order.
Or direct order.
And that order was passed on 1/7/2009. Thereafter, you filed review petition. Review petition came to be dismissed on 11/1/2011. Thereafter, you have implemented the order only on 11/3/2011.
May I read that one paragraph of that order of 1/7/2009, wherein as per this order,
other petitions.
Yes.
How many cases your client had filed? Just give the list of cases because we want to levy the cost. How many cases were filed earlier?
Earlier,
please give the list of the cases.
Yes, madam. Just now.
the governing body, my lord, shall I read that 17/2009 order? What was the case of the governing body before this honorable court? Only because my lord have put me question with what you have disclosed. The governing body has stated, para 2 of that order itself. Dispute in this writ petitions is with regard to the intersessionality regulation of lectures appointed in faculty of physics at Ispat College, Rourkela. Admittedly, several persons were appointed as lecturers on part-time basis in the Department of Physics in this said college and different dates. While matters stood thus, management decided to disengage part-time lecturers and appoint regular lecturers. In consonance with this said decision, an advertisement was published in the newspaper inviting application from the interested and qualified persons in the year 1994. Yeah. It is submitted that again in the year 1997, another process of recruitment was conducted. From the averments made in the writ petitions, it appears that the petitioners in all the cases, as well as the intervener opposite party, Sri Devashish Das, submitted application in response to the advertisement along with others. The governing body conducted an interview, and in the said interview, it is submitted that Devashish Das stood first and he was appointed in the regular basis as a lecturer in physics. The said selection was essayed by Sri Rameswar Prasad Mishra in WPC 11663 of 2008, in OJC 9966 of 1997. After hearing the Land Council for the parties, division bench of this honorable court disposed of this said writ petition on 12/5/2005 with an observation that if Rameswar Mishra would file a representation before the Director Higher Education Odisha highlighting his grievance, the said authority shall consider the representation in light of the judgment passed in OJC 7777 of 95. It appears that Sri Rameswar Prasad Mishra filed a representation and the Director initiated a proceeding, called for documents and directed the parties to appear for the personal hearing. The Director, after hearing and considering the document produced, came to a conclusion that Sri Rameswar Prasad Mishra was in fact denied natural justice inasmuch as though he was in a better footing than others, his case was ignored. The Director disposed of the representation observing as follows. Therefore, without prejudice to the claim or claims of others, the Principal Secretary, Ispat College, Rourkela, opposite Patna 4, is directed to reinstate Rameswar Prasad Mishra as a lecturer in physics within 1 month from the issuance of this order. Then, the order passed by the Director is asserted by the governing body in WPC 9601 of 2006. On the other hand, Sri Rameswar Prasad Mishra has filed WPC 11663 of 2008 with a prayer to direct the state government to implement the order passed by the Director. After receiving notice, all the parties have appeared and received pleading are complete. In course of hearing, Mr. Swain, Land Council, appearing for the governing body, submitted that Sri Rameswar Prasad Singh was appointed only in part-time basis and was continuing as such. But then, after managing committee of the college to take a decision to disengage all part-time lecturers where there were surplus staff, the period of engagement of Sri Rameswar Prasad Mishra was not extended. Consequently, he was disengaged from service. The submission made by Mr. Swain are strongly repudiated by Mr. K.P. Mishra, Land Council, appearing for Rameswar Prasad Mishra. Accordingly, to him, Sri Rameswar Prasad Mishra was all along continuing and Director after hearing all the parties and perusing the relevant records has rightly come to the conclusion that he should be reinstated in service. Admittedly, Sri Devashish Das, intervener opposite party, who stood first in the selection and had been appointed as a lecturer in physics, has not filed any writ petition and more or less support the stand taken by the governing body. We have heard Land Council for the parties at length. We peruse all the pleadings as well as the documents annexed to the writ petition and counter affidavit meticulously and thought over the matter diligently. Accordingly, the governing body of the order passed by the Director Higher Education Odisha directing management to reinstate Sri Rameswar Prasad Mishra was not just and proper. According to the governing body, the order passed by the Director Higher Education Odisha directing management to reinstate Sri Rameswar Prasad Mishra was not just and proper. On the other hand, according to Sri Mishra, and counsel appearing on behalf of Sri Rameswar. Again, no, this is all these contentions. Yes. Also, my lord wanted to know what was my contention. That is there in the court. That is why I am reading out.
Only oral contention without filing any objection.
No, these documents were there in the writ petition with regard to that part-time and all this.
See your conduct, I tell you.
And my lord, finally the court has said that implement the order of the Hon'Ble Court. That was the order. So now, my lord, my respectful submission is this petition, this opposite party has appointed on part-time basis. And the Hon'Ble Court, in the impugn order, what it has come to a conclusion, you must give him a regular appointment. My respectful submission on law passed, my lord, since the governing body has no authority now because of the change of rules and all these things. It is only because rule 8.
That contention you had not taken up.
Where, madam?
This contention which you are now pressing into survey was not urged before the learned single judge.
That is a point that at the outset I have stated where no counter was filed in that case. So only therefore I will place the law. Law before this honorable.
This is an appeal. Appeal is on the view of learned single judge.
Right.
We do not have the benefit of view of the learned single judge at a particular point, which now you are canvassing before us.
Only
because you had not taken up that contention before.
That no contention.
Therefore, we have no jurisdiction to entertain that.
Only thing I want to submit, my lord, since it is a point of law, at the appeal also I can raise this, and that is why I am showing, my lord, the law. Because admitted fact, we have not contested the case.
Can we see the conduct of the management?
That is, my lord, may not say anything because
No,
I have
say that.
because I was not the counsel all
this
through.
we are saying because we want to. We are not just.
I am standing here only to.
That's one. We want to dismiss it with exemplary cost of 5 lakh rupees for this reason. Director's order was 19/6/2006.
I know.
And the direction for implementation was 11/3/2011.
No, 1/7/2009.
No, you did. That is much only thereafter.
It is before that. Implementing with direction to us to implement it was 1/7/2009.
1/7? No, 19/6/2006. 19/6.
Director's order. High Court order.
Yes.
Yes.
You did not implement director's order. You made her to come to the court, and not only that, you challenged that.
Challenge it.
That challenge was repelled on 11/3/2011. Thereafter, the direction came to be issued with the division bench on 1/7/2009.
No, that is before.
No,
my lord.
WP 11663 of 2008 was disposed of on 1/7/2009.
Yes.
That is the order. It is a division bench order.
And in the relevant time, my lord, all the matters coming on the division. There was no concept of single.
Anyway, then review petition also came to be rejected on 11/1/2011. You lastly issued the appointment order on 11/3/2011.
Yes. That is the point. And thereafter, but this cause of action for filing of the present writ petition against which we are here, that was filed because of a further termination order on 21/4/2011. Against that says file an writ petition instead of filing an appeal. Be that as it may, now Hon'Ble Court has said you accept him as a regular teacher and issued an appointment order in his favor. My responsible submission, because as I have only not to repeat further, we have not filed any counter. We have not contested the case in that way what we should have been. But what we have done, my responsible submission before this Hon'Ble Court is, my lord, because the law does not permit a governing body of a graded college to appoint anybody.
You have said
only, my lord, that is the point of law. Only I want to canvass.
We have already said.
Yes, ma'am. That is the. Shall I show that provision of law, madam?
No, why? Therefore, you did not tell it to the learned single.
Yes, that's true, my lord. Nothing will.
If you want, you go before the single judge. Otherwise, you are dismissing.
No, we have filed a review before the single judge with these facts, my lord. We have filed a review. Review has been dismissed. Thereafter, I filed it because, my lord, in the past there are 2 cases. First case was dismissed. Thereafter, a review was filed. The review was dismissed. Thereafter, only this appeal was filed. Therefore, a delay of 240 days. The review was dismissed only on 19/3/25. Against this order.
Do you want to say anything on a proposal of cost? We are thinking of living there since so many years. She has been here to suffer. We should do.
My responsible submission is, for the governing body, there is a collective decision of a governing body, and the private management run by those private persons, they are changing every 3 years. Whatever the decision they have taken, the principal who by defect he became a default, he became the secretary of the governing body because he is a teacher. He has to only carry out the decision what they have taken. And now, my lord, in the governing body, the sub-collector and all these officers are there. The principal, only on the instruction of the authority, he has filed this case. So imposing, and that person has also been retired long since. Now somebody might have come. My lord, will only given indulgence.
Yeah.
This at least the governing body has a case, so far the present case is concerned. I am not going to that 2006 and all these things. If my lord will give an opportunity by remanding the matter to the single judge, will place all these facts again.
No.
So that this finding, it will create a difficulty in the, not for this institution only, because there is no vacancy. Because in the first paragraph itself, that Devashish Das has also tried to intervene in this case, writ petition. The Honorable Court has protected him.
Yeah.
But fact demands, Devashish Das has now been given the block grant and all these things. What he is getting?
Dismissed with the cost of rupees 1 lakh. There is amount to be remitted to paid to the respondent employee within 30 days, failing which another sum of rupees 250 per day for the first 30 days and rupees 500 for the days next following. Yeah.
Item 22.
I have given the list of the cases where I have appeared.
Yeah.
In item number 22, so Lord, in that case, I am appearing on behalf of the contesting respondent number 1. The respondent number 1 is the only contesting party in this list, Miller. This matter was before your lordship on 27th Miller, January last 27, and pursuant to the notice issued by another coordinated division bench Miller, headed by Honorable Chief Justice Miller, presided over by, I had order dated 6 January, issued notice to the respondent Miller. I am the respondent number 1. I have filed my person today Miller. I have served a copy of my learned senior, just designated lawyer Miller. I have filed other two copies of the
No, therefore we are asking, do you want time?
I want some time.
When do you want?
Any convenient date, any convenient date of your lordship, as well as my senior friend also. 1 week after means within 2 weeks, Miller, maximum.
Yes.
Miller.
We commencing 16th.
No, the date may be fixed, Miller. Your lordship.
17 you can take.
Take up on
Call on 17 at the request of, unanimous request of the arguing counsel. Yeah.
Miller,
23.
interim order may continue.
Interim order. You have interim order?
Yeah, interim.
Let it come in the last week. Last week of February. Yes, interim order to continue.
Grateful.
Item 23.
Miller, your lordship can fix up the date. I have no objection. Last week, your lordship can fix up the date. 20 for your lordship can say.
Item 23.
Item number 20. It's a cover matter, lordship. In the last occasion, dated 12/1/2002, copy sought to the AGH for a
verification.
No. Copy sought to, this is identical or not identical?
You have to give copy, na?
Yes, sir, they last week, they also submitted the copy. So it is a rehabilitation scheme. That's the applicant.
This after your lordship 26 years. It was first applied in the year 2000. In the meantime, that 1990 rules has been overruled, where married daughters can get rehabilitation assistance.
Repealed.
Yes, repealed. And your lordship, here basically it is in a distress position where the
What is the age? It's a compassionate appointment.
Yes.
What is the age of your candidate?
So when you filed the
18 years was at the time of seeking appointment, it was 18. Now already 26 years have passed, your lordship. And she's already married, residing with her husband.
What to do? Can she stop marrying?
And she's also taking care of her mother. She's also taking care of her mother.
So only doctor was
at that point of time, the rules said that married daughters are not entitled for rehabilitation.
No entitlement.
Yes. At that point of time. Now it has been repealed.
That was wrong. No, it was rejected.
Yes,
it was rejected on that ground.
Yes.
Yes, it was rejected on the ground that married daughter is not entitled to.
That has been challenged before the lordship. After 30 years service of the deceased father died, lordship applicant already applied. That time is unmarried.
Whether pension is family pension is given to the widow?
No.
No family pension?
No.
He was a Mazdoor, classic. I'll get the instruction as to whether family pension is being given.
No family. Family already, mother already died, 2006. And after completion of 6 years, 99 applicant applied the post of revenue assistant, and that has been approval by the government under Annexure 5 lordship. The government already approved the post, approval the appointment of the petitioner under Annexure 5 page. That has been
then it was
not been given appointment. Therefore, applicant challenged the tribunal. Tribunal to direction to the consider the case of the petitioner.
Whether government had issued appointment order?
Yes, my lord. Annexure 5, lord. See, kindly page. Annexure 5, page 19. The post was approved already. Approval of the proposal of the appointment of the Kumari Moni Macha, Dr. Later Hari Macha, ex Khalasi under the Revenue Assistant scheme, lord. Government address to the chief engineer, and the chief engineer address to Annexure 7 to chief construction engineer or OP number 4 lordship. But they are not given up.
Yes, madam.
But your
Come
lordship-
to Annexure 5,
Yes, your lordship may see.
dated 6/4/2010.
Yes, at 2010 it was approved that she should be given a rehab.
Who approved? Additional secretary?
Yes, your lordship. But in the meantime, while the time they were going to give her appointment, it was found that and in the year 2006 she got married. So at the time of appointment, she was already married, your lordship.
Correct. Unless that, see, which is that section in the Indian Succession Act. Marriage shall not disentitle any person to any privilege which she is entitled to.
But at that point of time, the 1990 rules were in force, your lordship, and there section 2B had said that unmarried daughters are not entitled, your lordship.
6/4/2010.
They are not coming under the family, your lordship. It was 2B of the 2B3 of the said rule only clear unmarried daughter are the members of the deceased family to be eligible for avail the benefit under rehabilitation assistance scheme. Accordingly, the engineering water resources had.
See, kindly come to 6/4/2010 order, Annexure 5.
At the time of apply, unmarried, they are up to married. After 7 years.
Kindly sit down. You may file your case if we permit you. Yes.
Yes, sir.
Kindly read that.
I'm directed to invite a reference to a letter number.
Who has sent author? Who is the author of this?
The author is Additional Secretary to Government.
Additional Secretary.
Yes.
So it is a government.
Yes, Your Lordship.
Additional Secretary means government.
Yes, Your Lordship.
Government issues to whom?
To the engineering in chief.
Whether government is superior or engineering chief is superior.
Government.
Government is superior. What the letter says?
The letter says that I am directed to invite a reference to your letter such and such in 2009 and such in 2008 of the aforesaid proposal to say that the Commissioner cum Secretary has been pleased to approve the above proposal for appointment of Kumari Moni Macho, daughter of late Hari Macho, as a peon. Yes.
Under RAS.
In the
it is saying
control.
letter. The chief engineering chief has sent a letter.
Yes.
Proposing to appoint.
Yes, Your Lordship.
That letter proposal is approved by the government. Who?
Yes.
Secretary.
Yes, Your Lordship.
Additional secretary informs it. Our secretary has approved appointment.
Yes.
Will it not give right?
But Your Lordship, when the proposal was finalized by the government, Your Lordship, in the meantime she had got married. So when
Which says till to get marriage, she should to get appointment. Can she be asked to wait?
That is the only.
How you can ask somebody to postpone the marriage
on the date of applying under the RSS, she was not married.
That is the point now.
Yes.
That is the only point which learned single judge appears to have missed it. Which is that section? There is Indian Succession Act. There is one section which says marriage per se will not result into incurring any liability, disability.
Success not a rule 20 lordship.
Section 20.
Yes. And lordship also, judgment also.
We have held that way in some judgment. Take out that. You can't ask somebody to postpone the marriage or not to marry because these are all personal freedoms. And one will have fear that you may not give the appointment at all. Even if I wait, I become ace barred for marriage. In the matrimonial market, even if one candidate loses his matrimonial point, there is no guarantee that you will give the job to him, her. Section 20. Interests and powers not acquired nor lost by marriage. See how section is. Kindly read this section for a moment. This is parliamentary intention. Give that time. Read loudly. There are many youngsters, they may be interested in knowing the law.
21 says effect of marriage between persons.
20.
Interest and powers not acquired or nor lost by marriage. 1. No person shall by marriage acquire any interest in the property of the person whom he or she marries, or become incapable of doing any act in respect of his or her own property, which he or she could have done if unmarried.
And the philosophy underlying, though it is the property specific,
yes,
the underlying philosophy in the feminist movement is the woman should not be, or man also, it is gender neutral. No person should be deprived of a particular benefit, of course, in the property, only because he or she contracts the marriage. That is the underlying philosophy. If that is so, as on the date, because your rules do not say, till we issue the appointment order, you should not make, and you could not have made such a rule at all. As on the date, he applied. Not married.
Not married.
How learned single judge has treated that contention?
Yes.
Learned single judges are.
Yes.
Annexure D, Annexure D, your lordship, of our counter, of the counter affidavit, your lordship.
What it says?
It says that peruse the pleadings and documents annexed thereto. The applicant seeks an appointment under rehabilitation assistance scheme on compassionate ground due to the death of a father, who while serving as a male mazdoor under work charge established under Potera Irrigation Project Bariamalas died. Previously, the applicant had made a representation which was duly forwarded, and after due consideration, finally it was rejected via impugn order dated 9/6/2011 at Annexure 9. It is stated that in the year 2006, the applicant got married, so she is not entitled to get an appointment under Rehabilitation Assistance Scheme. Under Rehabilitation Assistance Scheme and the rules framed thereunder, that is OCS Rehabilitation Assistance Rules 1990, a family member of the deceased employee is to get such an appointment. Family member has been enumerated in Rule 2B. It is explicit that there
excludes married person.
There it is not included a married daughter.
Correct. Married daughter as on the date of death of the employee. The relevant date is death of the employee in harness.
So it says Rule 5 provides appointment of a family member. In 2006, when the applicant got married, she is ceased to be the member of the deceased employee as enumerated in Rule 2B. So she cannot be appointed under rehabilitation assistance rules. The applicant had previously approached this tribunal for filing an original application registered such and such, wherein this tribunal had directed to consider the claim of the applicant by order dated 11/3/2011, and the respondents have rejected the same via Annexure 9 on 9/6/2011. I peruse the same. The basic reason is that the applicant, having been married, she is no more a member of the family of the deceased. I do not find any malafide or arbitrariness in such an order of the executives. Thus, the claim of the applicant is not meeting.
This is the order of the waiting.
Yes.
Yes, sir.
Take up. Tell me the date of death.
Date 21/8/2019, 20/12/2099. Let's see. Annexer 3, Lordship. Annexer 3. That's the death certificate.
How many times he died? If one can die.
He died on 2012-1999.
Annexer 3, 20/12/99.
1999.
2012 to 99.
He was a peon.
He was a
Khalasi.
Mazdoor. Khalasi.
Khalasi.
Yes.
Helper. Is he helper?
Yes.
Khalasi.
Khalasi Mazdoor.
How many years of service he has put in?
30 years.
30 years.
69 to 99. Service book, first page, Annexer 1. 15/7/1969 has entered in the service.
67.
15/7/1969. 15/7.
And the age of appellant was what? Petitioner was what?
The legal hair, that is the 18 years.
He was 18 years as on the date of death.
Death.
Applied on which date?
21/8/2000, Your Lordship.
The apply on 2000, Lordship.
21/8/2000.
21/8/2000.
Actually, that's
Married on which date?
On the 2006.
On which date?
18 years.
Date. Date.
Go to Annexer 5. Widow died on when widow died?
Widow died in 2006.
He also died in 2006.
Thereafter, he has married and only daughter.
Huh?
She has a mother has also given an affidavit that my daughter is married and I'm residing with her.
Kindly sit down. Sit down. Facts of this case are appalling, to say the least. First, the father of the petitioner died on 20/12/1999, having put in 30 years of spotless service. First, death was in harness. First, his widow, how many children?
Only one daughter. Only one.
He had left behind the widow and a son, namely the petitioner.
It's a son,
Daughter, namely the daughter. First, petitioner applied for compassionate appointment, wide application dated 21/8/2000. First, the government wide letter dated, sorry, the engineering chief wide letter dated 26/10/2009 and letters dated 26/8/2008 and 26/10/2009 had solicited the approval for compassionate appointment of the petition. First, the additional secretary to government, wide letter dated 6/4/2010, conveyed the approval granted by the secretary to the government for such appointment, subject to production and verification of documents 5 documents then listed there. First, however, the appointment was denied on the ground that the petitioner contracted marriage in 2006. First, aggrieved thereby, petitioner knocked at the doors of Orissa Administrative Tribunal in OA number 11, which came to be negative. While order dated 8/11/2011. First one. Grieving against the same, petitioner is knocking at the doors of High Court. Next paragraph. Learned counsel for the petitioner submits for a compassionate appointment, comma, the relevant date for consideration of credentials is the death of employee in harness, and that what subsequently happens after the filing of claim for compassionate appointment is not much relevant. First, he submits that the authorities are not justified in denying appointment on compassionate ground on the premise that the petitioner has married when her application was pending consideration. Kindly be seated. Learned AGA appearing for the OPs vehemently opposes the petition, making submission in justification of the impugned order and the reasons on which it has been constructed. First, she tells us that the married daughter would go out of the definition of family under the extant rules providing for rehabilitatory scheme, and therefore the reasoning of the reasoning of the tribunal cannot be altered. First, next one. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter for the following reasons. First, one, petitioner's father was in the employ of the respondents during the period between 15/7/1969 and 20/12/1999, continuously and without any blemish. First, he died in harness on, that is not 20, it is 1912. He died in harness on 20/12/1999, and the family was in distress. First, his widow having filed no objection, comma, petitioner staked her claim for compassionate appointment on 21/8/2000. First, in the process of consideration of the claim for appointment, comma, petitioner was getting aged, and she entered the wedlock in 2006. First, the stand of the respondents that petitioner having contracted marriage has become disentitled to stake her claim for appointment of the kind is difficult to countenance. First, though compassionate appointment is not a matter of right, when there is a state policy governing the same, the privilege graduates to the level of right. First, the extant rules, which are the rules of which year?
1990, you know.
Can you tell the title?
Yes. Orissa Civil Service Rehabilitation.
There is a policy promulgated in the Orissa Civil Service
Within bracket RA rules 1990.
Rules 1990. First, the definition clause. In the definition clause, family does not include married daughter, married son or daughter,
Daughters.
married child,
Daughter.
married daughter, married daughter. Full stop. To decide whether the claimant is within the parameters of this definition, the relevant date is the one on which the employee died in harness, or at least the one on which the application is made for compassionate appointment. First one. There is nothing in the rule that would give scope for an otherwise view. First one. Otherwise view cannot be there because marriage, it is within the common knowledge that persons enter wedlock at the marriageable age. First off, they cannot be asked to wait indefinitely for the government to take the decision, authorities to take the decision on the claim for appointment on compassionate ground. First off, otherwise, they may not only get the government job, but also a potential spouse as well. First off. Therefore, the premise on which the claim is turned down is defective. First one. A learned single judge of this next one. You're right. Section 20 of Indian Succession Act 1925 gives a clue as to why marriage is not a disability in matters of interstate succession to property. First off, the underlying principle of this provision should animate the operation of the 1990 rules, there being nothing to the contrary. First off, Section 20 reads, Section 20 subsection, section 21 into bracket of the Act reads as an. Next one. When we see this, this decision is put in appeal in next one. Just very whether it's put in appeal. A learned single judge of this court in wait, don't now I'll give the judgment back. Okay. Do you have
referring this judgment? Another two judgment already passed by the coordinate bench. Lords, you can pay.
Coordinate bench?
Yes, ma'am.
Our coordinate to us?
Yes, no, Lords.
So is that let's go.
Referring to.
There is one apex court judgment. We have judgment by Justice Nagaprasanna of Karnataka High Court.
Yes, but for the paragraph 18 and 16.
In this judgment?
Yes, ma'am. The Basanai cases already.
In Basanti Naik, it is referred.
So Basan Naik refer kari out the coordinate bench judgment is na Basan Naik case paragraph 18 the Supreme Court judgment already.
No, that was about 2 years ago.
Yes.
We have that.
Yes.
This one.
This is Ranjana Muralidhar Ante registered.
Huh?
So. 11 and 12 paragraphs clearly mention the apex court judgment in Sri Ranjan Muralidhar are a state of Maharashtra. Paragraph 11 and 12.
The apex court in Kshiravadi Bala Behera. No.
Hiraddi Bala Behera.
Behera is from Orissa High Court.
Yes.
Single judge.
Yes. As a single judge,
is it single judge?
Hiraddi Bala Behera case.
No, is it
Is it a single judge or division bench?
Single.
Single judge. The learned single judge of this court in WPC number 14945 of 2015 between disposal of on so and so has observed as under. Is you reproduce it.
So in comparison to that case, W is there.
W is the pending
Disposed of.
disposed of.
One content is also there.
Disposed of even affirming or reversing the judgment. Anyway, leave it. This is just put second. Below that one line. We are in complete agreement with the above view. Above view. First one. Next. We fail to understand how appointment could have been denied to the petitioner lady, despite there being approval to the proposal for appointment by virtue of additional secretary's letter dated 6/4/2010, in principle agreeing with the proposal sent by the engineering chief, while letters dated 26/8/2008 and 26/10/2009. First up, the said letter, a copy whereof avails at Annexure 5, reads as under. Annexure 5 to the W. Okay? Reads as under. Which is also directed to implementation by the next lesson. Further, the engineering chief, while letter dated 25 May 2010, directed the chief construction engineer as under. As per Annexure 6. Annexure 6. First one. Thus, the impugned order of the tribunal spurns at the principle of equality, gender equality, enshrined in Article 14 of the Constitution of India, and also a long line of decisions. First, in the above circumstances, this petition succeeds. The writ of certiorari issues quashing the impugned order of the tribunal. Second,
Annexure 10 lords.
Petition tribunal.
Tribunal order Annexure 10 lords. Dated 8/11/2011.
Next.
And the
writ of certiorari issues quashing the order, which is that order?
Order that Annexure 10, OA number
10.
Government order Annexure 8 lords. Dated on 9/6/2011.
Office order dated 9/6/2011
under Annexure 8.
At Annexure 8.
Yes.
Second, the writ of mandamus issues to who?
OP number 1.
To OP number 1.
Because the Annexure 1 is Annexure 5 to OP number 1. They
to issue or cause to be issued the order of appointment on compassionate ground in favor of the petitioner within 6 weeks, failing which, per day of delay, 500 rupees shall be payable to the petitioner, and this amount should be recovered personally from the erring officials of the department. The compliance order should be, report should be filed with the Registrar General of this court within 2 weeks after
Your Lordship, it should be to the engineering in chief, Your Lordship.
Will issue engineering chief. Yes. Therefore, we said issue or cause to be issued, whoever.
Your Lordship, 8 weeks.
8 weeks. All right. 8 weeks. Okay. Already, report compliance to extraction to structure plan.
Highly obliged. Highly obliged.
Okay.
The decision of the division bench already. Appeal case that's already disposed ହେଇଛି. So single bench order ଟା
Is affirmed by the division bench.
Yes, ma'am. WPC number 14945/15. Dispose on 24/8/2022.
No, how can that be? It's a single judge.
Single judge bench appeal before by the government appeal division bench is appeal that disposed ହେଇଛି.
Appeal is dismissed.
Yes, ma'am.
Anyway, we have not referred to that.
You're obliged. That's obliged. Highly obliged.
Yes, we have dismissed on delay. Special bench into the language. We are going because we have approved for meeting.
4/5/15.
Yeah.
I'm at item number 26 matters.
They will come.
No, tomorrow. My prayer is for tomorrow because it is very urgent because my promotion is held up because of the disciplinary proceeding matter. No, disciplinary proceeding matter. Please, my lord.